Okay, we're back live. Ms. Watt, good morning.
Good morning, Your Honor.
What can I do for you?
I have Darnell Clemons. He's in custody.
Okay. Did you want to wait on him or waive his presence?
Waive his presence, please.
Okay, we're ready.
On the case number 2305-894701, before the state of Michigan versus Darnell Clemons. Defendant is charged in count 1, assault with intent to degrade bodily harm, less than murder by strangulation, count 2, domestic violence, aggravated, second offense limits. Defendant also has case number 2305-894801. Defendant is charged in count 1, assault with intent to degrade bodily harm, less than murder by strangulation, count 2, domestic violence, aggravated, second offense limits.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning again, Your Honor. Coral Watt appearing on behalf of Mr. Clemons, P41508. I'm asking to waive his presence.
Defendant's presence, what's your pleasure?
I'd like to set this for preliminary examination.
Yes, 2 cases. The court will continue to plead not guilty as to both matters, set in both for preliminary examination. How is October 2nd at 9:30?
That will not work, Your Honor. I will be in Ohio on that day. But I can do the next day, the 3rd.
No, that's my homicide day.
Okay.
October 4th.
Yes. And could I have it at like noon on October 4th? I'm asking for that because I'm going to be in trial, but I know we take a break at noon. So I will run over and do my exam.
All right, October 4th at 12 o'clock, both matters.
Thank you, Your Honor.
Continue. Thank you. Jennifer Hawley.
Good morning, Your Honor.
Good morning. What can I do for you?
I am Marcel Carter's juvenile probation officer. I just need to know what's going on with his adult hearing.
Said Marcel Carter. Okay, we haven't seen his attorney yet. So there's a time set for a competency hearing. I'm not sure if I have a report back. Mr. Fedor, did you get a report back?
I did, Your Honor. It does indicate that Mr. Carter is competent. I have sent Mr. Shark a text message, gave him a call, haven't received a response.
Okay, so we're gonna most likely set a preliminary examination date, Ms. Hall,
Okay.
once his attorney gets here. Morning, Mr. Chard.
Good morning, Judge. How are you this morning? Sorry to keep you waiting.
Probably okay today?
Doing great. Thank you, Your Honor. Appreciate it.
You're here on Carter, correct?
That's correct.
Okay, correct.
The case number 2305-55610, people of the state of Michigan versus Marcel Carter, beginning number 1. Count 1, homicide, felony murder, juvenile defendant.
Appearances for the record, please.
Good morning, Your Honor. Mark Fedoruk for the people, P76177.
Good morning, Your Honor. Stephen Sharg on behalf of Mr. Carter, P43732.
Are you waiving Mr. Carter's presence for purposes of this hearing?
Yes, Your Honor.
The court will waive the defendant's presence. Today's date time set for a competency hearing. Did you receive a report from the forensic center, Mr. Sharp?
I have, Your Honor. I have reviewed it, and I have no problem with the findings at this point in time.
My understanding is that their finding is that he is competent to stand trial. Is that right?
That's correct, Your Honor.
You're stipulating to that as well as you, Mr. Fedor?
We do, Your Honor.
Yes, Your Honor.
So the court makes a finding that the defendant is competent to stand trial. What's your pleasure now, Mr. Sharp?
Judge, can we set this down for an exam date, Your Honor?
We sure can. How is October 3rd at 11:30?
Can't do the 3rd, Judge. I could probably do the 4th if the court's in the afternoon or late morning.
Tuesdays and Thursdays are what I'm limited to.
Oh, Tuesday and Thursday. Okay, I'm sorry.
How do you look on the 5th? 11:30 or 1:30?
I could
Could we
do
do
1:30.
1:30?
1:30, Judge?
1:30 on October 5th?
Yes.
So
And that works
October-
with people.
Ronald, you continue.
Thank you very much, Judge. Appreciate it.
Thank you, Your Honor. Have a good day.
You too.
Thank you. Mr. Kenneth,
Good morning, Judge.
what can I do for you?
I have the 10 o'clock exam, but there may be a waiver. I'm just waiting for prisoners to talk to them one last night.
Okay. Wayne County Jail, what's your name, sir? Unmute yourself. Sir, in the Wayne County Jail, unmute yourself and tell me your name. You might need to get some help, sir. What's your name, sir?
Cedric Williams.
Oh, Cedric Williams. Good morning, sir.
Good morning, Your Honor. How you doing today?
You're only about 24 hours late.
My apologies, Your Honor. I had a death in my family yesterday morning.
My condolences to you. That's right. I didn't mean to give you a hard time. I forgot about that. My apologies.
No problem, Your Honor.
Okay, so you're here on Cedric Williams, correct?
Yes, Your Honor.
Okay.
Calling case number 2305-896501. People of the state of Michigan versus Cedric Williams. Defendants charged in count 1, assault with a dangerous weapon. Count 2, weapons stolen firearm. Count 3, domestic violence.
Appearances for the record, please.
Good morning, Your
Good
Honor.
morning.
Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Jabari Prempeh, P81745, on behalf of Mr. Cedric Williams.
Mr. Williams, tell me your name for the record.
Cedric Williams with a C.
What's your pleasure? What's your pleasure, Mr. Prempeh?
Your Honor, I do have discovery. We're ready to schedule this matter for preliminary examination.
All right, the court will continue to plead not guilty and set this matter for preliminary examination. How is October 2nd at 9:30?
That should work fine. That should work fine, Your Honor.
All right, October 2nd at 9:30, bond will be continued.
Your Honor, may I have a breakout room with my client, please?
Okay. Go ahead and join the breakout room. Have him help you join the breakout room, sir.
Excuse me, can I get some help? I'm gonna join the breakout room.
Mr. Morris, we're just waiting on your attorney, sir. Let me know when you're ready, Mr. Kenneth.
Okay.
Does the name Eric Wise mean anything to anybody? Oh, Ms. Martin, I didn't see you over there. What can I do for you?
Good morning, Judge. I have an examiner.
Okay. It's 9.
Yeah.
What's your client's name?
Eric Thomas.
It's a probable cause conference at 8:30.
Really? When I just went to a probable cause conference, so it said first Sam today.
Is this a case that came from Judge Secretary?
Yes.
Set for, because we may even set for an exam with her, but not, we don't have the same step.
But somebody even told me, and they didn't tell me they was moving it, and they didn't tell me it was changed for PCC. They didn't tell me, I just showed up to Judge Shabri, and she said, go to Judge King. But I'm here, my client's here. We set for it in my day.
Was it set for exam? Yes.
Calling case number 23058845015. People of the state of Michigan versus Eric Thomas. Defendant is charged in count 1, assault with a dangerous weapon, count 2, weapons stolen firearm, count 3, weapons firearm possession by felon, count 4, weapons stolen firearm. Defendant has a third offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Alicia Mariana, P69003, on behalf of Mr. Thomas, who is present, standing to.
Tell me your name for the record, sir. Eric Thomas. Mr. Thomas, thank you very much for coming to court dressed appropriately. It's refreshing. I appreciate that. You may, you ain't counsel. What's your pleasure, Ms. Martin?
Need to set for preliminary exam, Judge.
Court will continue to plead not guilty, will set this matter for preliminary examination on how is October 2nd at 10:15.
That's the page.
October 2nd at 10:15, Mount Eagles.
Thank you, Judge.
Thank you.
Ms. Bonomo, what do you
Yes,
have?
ma'am. I have Michael Asaro, defense counsel sitting in the courtroom. We maybe a waiver.
Is that the one with Mr. Connected?
Yeah, he's in the courtroom.
Oh, okay.
Just waiting for the prisoners to come up.
Oh, you're just waiting on the defendant.
I had to plug in on that, so.
Okay, no problem.
They let me sign yesterday when I looked. Yeah. 'Cause
Mr. Sullivan, good morning.
Good morning, Judge.
What can I do for you?
I have a PCC for Jakari Sanders. I apologize that I'm a few minutes late.
Okay, we're ready on Sanders.
Case number 2305-897201 for the state of Michigan versus Jenkins Sanders. Defendant is charged in count 1, unlawful imprisonment, count 2, domestic violence aggravated. Defendant also has case number 2305-897301. Defendant is charged in count 1, assault with intent to violate harm less than murder by strangulation, count 2, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Judge. Neighborhood Defender Service by Andrew Sullivan, P84261. Here on behalf of Jakari Sanders, who is in the Wayne County Jail. Not sure if he's been brought by Zoom. If not, I would waive his appearance.
The court will waive the defendant's presence. What's your pleasure?
Judge, requesting a in-person preliminary exam, all discovery, including digital discovery, and then if we may be heard briefly on bond.
Court will continue to plea of not guilty, set this matter for preliminary examination. How is October 2nd at 10:30?
Let me look at my calendar. Judge, I am potentially going to be in a trial on October 2nd. Is it possible to look to the 3rd or the 4th?
Going to be in trial all week?
I think it's just going to be a one-day trial, Judge. Yeah.
Okay. So the 4th. Let's do October 4th at 10 o'clock.
That's perfect, Judge. Thank you very much.
As to bond?
As to bond, Mr. Sanders does have 2 cases on Your Honor's docket. He's got a $50,000 cash bond on both. That's unaffordable for him. He's not able to post that bond. You know, my understanding of a bond is that it's a condition of release, that Mr. Sanders has been declared releasable, but is now being detained simply because he doesn't have funding. It's my position, Judge, that violates the 14th Amendment. It also violates the due process clause. So I'm asking that the court set an affordable bond for him, perhaps a 10% bond. I think that he said that his family may be able to post something less than $5,000. He was working at White Castle. He has a young son, 2 years old. He has a place that he can stay separate and apart from the complaining witness in the case. I think that if Your Honor were to set, an affordable bond with a GPS tether or even with a house arrest, that would assure the community's safety and certainly Mr. Sanders' reappearance in court. So I'm asking the court for an affordable bond.
What's his current bond?
He has 2 bonds, of both of them $50,000 cash. So I think it's $100,000 cash total.
Ms. Drain?
Your Honor, I'm not objecting to a reduction in bond at this time. And with a tether and house arrest. And no contact with the complainant. It is the same complainant on both cases.
What can you post, Mr. Sullivan?
Well, I had asked that the court first consider a personal recognizance bond.
For me, no.
If not a personal recognizance bond, Judge, I'd request something, less than $5,000 with a 10% provision.
So $4,999?
I think that strains the upper limit of what his family may be able to post, and I certainly can't. I don't want to give the court any assurance that is affordable for Mr. Sanders and his family. So perhaps a $5,000 10% bond. I know that would be affordable for him.
Okay, I'll do 5,000, 10% on each case. House arrest, GPS tether, no contact with the complaining witness.
Thank you, Judge.
Thank you. Mr. Williams, you're all set, sir.
And Judge, before we're off the record on Mr. Sanders, I do have paper discovery, but not digital discovery. So I am asking for that to be sent, and I'll follow up with the court with a written discovery order.
And I'll just let you know right now, there is no digital discovery available for this case. I already looked.
Very well, but just for the record, I would still ask the court sign a discovery order.
Yes.
Thank you. And with that, Judge, I don't have anything additional on Mr. Sanders.
Okay, have a good day.
You as well, Judge. Thank you.
Connect your audio, Mr. Morris. Wayne County Jail, what's your name, sir?
Darnell Clemons.
What is it?
Darnell Clemons, Judge Kenneth.
Clemons? Mr.
Yes,
Clemons,
sir.
your next date is October 4th at 12 o'clock in 36th District Court for a preliminary examination.
So I don't have court today?
You had court today, they waived your presence. You set your next court date for October 4th at 12 o'clock.
October 12th?
October 4th at 12 o'clock.
October 4th. Okay, I have a question, Judge King. I was supposed to go for probation tomorrow at 36th District Court. I already had set it in place with my lawyer and the prosecutor. I'm trying to see, will I still be able to go over there tomorrow for my probation?
I have no idea, sir.
Okay, you said October 4th?
October 4th at 12 o'clock, yes, sir.
Okay, now one more question, Judge King. Who waived because I haven't spoke to a lawyer, nobody.
Okay, so your attorney is Coral Watt.
Oh, okay, yeah, because I didn't speak to anybody. Nobody told me this was happening or nothing. Is there any way possible? Can I speak to attorney?
I'm sure she'll make her way to you.
Okay, so do we want me to stay here or?
No, it won't be today. She's gone already.
Okay, you said October 4th?
Probably come to you in the jail.
Okay, and you said October 4th at 12 o'clock?
Yes, sir.
Okay, and she waived my preliminary exam.
No, she did not.
Oh, she did.
Presence for today.
I can barely hear you, Judge. Say that one time.
I said she waived your presence for today.
Okay, do you know why she did that?
Because you weren't here.
Yeah, I'm here. I was here in jail.
The jail didn't present you in front of the camera. So she just waived your presence just to set a court date, that's all.
Okay, so October 4th at 12 o'clock.
For the 5th time, yes, sir.
Okay, thank you, Judge. Can you have a good day?
You too. What's your name, sir?
Michael Arnell Hicks.
Mr. Hicks, your next court date is October 9th at 11:30 for preliminary examination in 36th District Court.
So this is not bond reduction of no kind. My lawyer won't be here.
Your lawyer was here already.
You said October 9th?
October 9th at 11:30.
Yes.
And I believe they requested a pretrial services review of your bond to make a suggestion as to what your bond should be. We'll take that up on your next court date.
Okay, Your Honor.
Excuse me, Judge King.
Yes, sir.
Sir, that's all I have for you.
All right, thank you very much. Have a good day.
You too, sir.
Yes, sir. Somebody call me? No, call me. Good morning, Ms. Woodside.
Good morning, sir. Sorry I'm late. I was in Oakland Circuit, just got out.
Okay, what can I do for you today?
You told me to check back in today for Mr. Whetstone.
All right.
I know my prosecutor said she'd be in a lot of places.
Who is the prosecutor on that? Oh, there she is.
Good morning, Judge.
Morning.
Good morning, we're ready on Whetstone.
Case number 2305-75690, people of the state of Michigan versus Trayvon Whetstone. Defendant is charged in count 1 criminal sexual conduct of first degree, count 2 criminal sexual conduct of first degree, count 3 criminal sexual conduct of first degree, count 4 home invasion, count 5 robbery unarmed.
Appearances for the record, please.
Good morning, Your Honor. Sonam Movsisian on behalf of the people, P83923.
Very good morning, Your Honor, to you and your staff at Police Honorable Court. Sharon Clark Woodside appearing on behalf of Mr. Trayvon Whetstone. Your Honor, for today's proceeding, I'd ask the court to allow me to waive his presence.
The court will waive the defendant's presence. What's your pleasure?
So, Judge, I did check with Dr. Miller. He is available. I've already got the request approved for him to do an evaluation. I've already put him in touch with the individual at William Dickerson / JDF for him to arrange to do the evaluation.
Most impressive, Ms. Woodside.
I'm on it, Judge.
How much time does he need?
About 2 months. That's the worst part. Then here's the thing, Judge. I asked for competency and criminal responsibility. I got a letter that talks about that they had sent you saying that they don't do competency to waive Miranda, but that wasn't ever requested. So the criminal responsibility was not done.
They don't do the criminal responsibility either, and I don't really need it for purposes of what I do here. That's a trial issue.
Okay. I just always make the request for both at the same time, so we're not hung up waiting, but no worries.
Okay, so I'll set a review date for November 27th at 8:30.
November 27th. Okay. Yeah. I will have a trial, but ooh.
Get here early, I'll do yours first.
Okay, yep, I'll try to log on right around about 8:15. I don't know how to pronounce your last name, APA. Could I give you my office number so you could give me a call when you have a moment?
Yes, please, because I'm also going to be in trial that morning. So if we appear right away, that would be helpful for me too.
My office is 313-965-3502.
3502. Okay, wonderful. Thank you.
Thank you, Judge, for indulging me. Have a wonderful day.
Thank you, you as well.
And Judge, just because I missed it initially, that date is just for us to come back for the competency, right? For the independent evaluation. It's not an exam.
Right.
Okay, thank you.
Have a
Take
great
care.
day.
Have a great day.
Connect your client here yet?
He wants his exam. I let the prosecutor know. I'm not sure if we're separate. Well, we're ready.
Okay, I'm ready when you guys are. I don't have anything else.
Right.
Yeah.
I just spoke with the family and I just need to still speak with my officers before they.
You got time, we're not scheduled to take.
I know, I'm gonna try to start early, but I just, yeah.
Whenever you guys are ready, let me know.
All right, thank you.
Ms. Bates, what can I do for you? Good morning, what can I do for you, Ms. Bates?
Good morning, Judge. How are you?
Good, what can I do for you?
I have the case of Laquita Green. For whatever reason, it was placed on Judge Sabri's docket. And when her clerk realized it was a DV case, I believe they transferred it over here. I'm not sure if you have the file or not yet, though.
Are you aware of that, Ms. Green?
I am, Judge.
Okay, do you have that file yet? Okay.
Calling case number 2305893501. People of the state of Michigan versus Laquita Green, defendant is charged in count 1, assault with a dangerous weapon, count 2, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Melanie Bates, P76080 from Randall Upshaw's office, appearing on behalf of Laquita Green. Your Honor, if she's not in the Zoom, I would ask permission to waive her presence just for today's hearing only. We are in communication with her.
Court will waive the defendant's presence. What's your pleasure?
Your Honor, we'd like to set the preliminary exam.
Okay, the court will continue to plea of not guilty and set this matter for preliminary examination. How is October 2nd at 11:45?
That will work, Your Honor.
Okay, October 2nd at 11:45, file will be continued.
Thank you. Have a good day.
Thank you.
Thank you. Good morning, Mr. Banton.
Good morning, Judge. How are you?
Good, long time no see. Where you been?
I've been sick.
Oh, I'm glad to see you back in the saddle.
Yeah, I feel a lot better.
That's good. You're here for Mr. Morris?
Yes, I am.
He's been waiting on you all morning. He gave
Yeah,
me
I
his
know.
phone.
I had a doctor's appointment at 7, a PET scan, and it took like an hour and a half. So.
Okay, we're ready on Morris.
Good morning, Your Honor. Richard Banta. Did you call the case?
Not yet. Give me a second.
All right.
Calling case number 23058555901. People of the state of Michigan versus Scott Morris. Defendant charged in count 1, assault with intent to regret bodily harm, less than murder or by strangulation. Count 2, domestic violence. Defendant has a habitual offender worth offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Richard Banta on behalf of Mr. Morris, P 39845. We'd ask that this matter be set for preliminary examination.
Mr. Morris doesn't have his audio connected to the court, but he is here. The court will continue to plead not guilty and set this matter for preliminary examination. How is October 2nd at 9:45?
9:45 should be fine, Your Honor.
The bond will be continued.
Did Mr. Morris ever get on?
He's here. He hasn't
All right.
connected to the audio though. He did give me his number for you.
All right, good. Can I get that, Your Honor?
What I'll do is I will put it in the chat. So
All right.
the whole can get it, okay?
Yeah, that's fine. Thank you.
All right, hang on a second. Okay, there it is.
Thanks, Judge.
No problem. What date did I give Mr. Cooper for Clayton? (10-2). Okay. I wrote 10-7 for some reason. That's a Saturday. Sure.
Well, I think I'm done for this morning.
You're all set? Okay.
I think so for all these 14 DVPCCs today.
I know.
That's a lot. Whew, okay. All right. I will see everyone tomorrow.
Okay, have a good day.
You too. Thank you.
You're all set, Mr. Morris. That's you, Ms. McGowan?
Yes, Your Honor.
Ms. Fellas? Prosecutor?
He's gonna jump on Zoom.
Oh.
Good. One of your, Washington on 130, it's gonna be a waiver.
Okay. See here?
Yeah, you can look now. So the prosecutor's gonna zoom in.
Okay.
Hey, so look, Washington. So it's you. Washington. No. Yeah, I'll hold it. Yeah, mine's better too. Oh, okay.
I dropped all these on the ground.
Get a few minutes, it's gonna be quick, but then, well, not actually. Yeah.
Yeah, you're. Did we all? Yes.
Yeah.
No, I.
So, yeah.
Yeah. Yeah.
Right. Yeah. It's way over. Sorry about that.
This one is this first client, Mr. Washington.
Yeah.
Calling case 2358625, people of the state of Michigan versus defendant number one, Jordan Wayne Washington. Defendant is charged with count one felony murder, count two felony firearm.
And Judge, I'm sorry.
Appearances for the record.
I don't see Mr. Vega on Zoom yet.
Oh.
He just texted me he's gonna do mine right now, but. if you
Good.
want on, I'm
He's
sorry.
active.
Yeah.
Mr. Bell is here. Okay, once again, this is case 2358625, people of the state of Michigan versus Jordan Dwayne Washington. Defendant is charged with count one homicide, felony murder, count two felony firearm. Appearances for the record. Mr. Vella, are you there? Please froze.
Judge, I'm
Good.
sorry, my screen was frozen. John Bell on behalf of the people, P68673.
Good morning, Your Honor. Neighborhood Defender Service of Detroit by Natalie Phelps, P83355, here on behalf of Mr. Washington, who's present in the courtroom. Mr. Washington, can you please state your name for the record?
Jordan Dwayne Washington. Okay, this matter is scheduled for preliminary examination at 1:30. So,
Judge, Mr. Washington wishes to waive his preliminary.
please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you, sir. You understand you have a statutory right to have a preliminary examination. By waiving the same, if you won't have one, you'll be found guilty to Wayne County Third Circuit Court as you stand charged with complaint form. You understand that? Yes. You understand the nature and purpose of the preliminary examination? Yes. You understand if you were to have one, the prosecution would have to establish that the crime the charge with was committed with the city of Detroit, probably cause of belief you committed it? Yes. Is anyone forcing you to waive the right? No. Is anyone promise you? No. Are you waiving your right freely, voluntarily? Yes. Any objection from the people?
No, Your Honor.
The court finds defendant's waiver is made knowingly and voluntarily, including given the court finds the defendant to Wayne County Third Circuit Court Criminal Division for the proceedings. His arraignment on the information date and time will be October 3rd, 2023 at 9:00 a.m. Defendant's bond. Continue.
Could we be heard on bond briefly? The last time that we were here, I believe we ordered a DSU report. Have you received that report back?
Mr. Giles, I have one for Washington. They recommend defendant agreement. Will actually take.
Judge, we're asking for a bond to be set and for a GPS tether to be imposed. Judge, Mr. Washington is only 21 years old. He has strong ties to the community. He obtained his high school diploma. Before he was picked up for this incident, he was working full time at Amazon. His first child was just born since he's been incarcerated on this case back on September the 12th. So we're asking for you to consider setting a bond for the GPS tether condition. He's not a flight risk, nor is he a danger to the community, so that he can spend some time with that brand new child, Judge, and
You guys can sign the waiver form.
Judge, can you ask the prosecutor, do he have a witness on detainer for us?
Mr. Vella, do you have a witness detainer on this case?
No, Your Honor.
No.
Your Honor, may I respond to the bond argument?
Go ahead.
Your Honor, we believe that this defendant is a danger to the community. This is a case where a robbery was set up. Two unarmed young men were in a car. The defendant and one of his co-defendants approached the vehicle. They shot 20 rounds into the car, killing these two young men in the vehicle, which they were waiting in. This defendant certainly poses a risk of danger to the community given his actions. I do believe the likelihood of conviction is extremely high for Mr. Washington. He did give a confession where he also indicated he was one of the shooters. I believe he stated he shot 3 rounds into the car at the driver of the vehicle. However, in total, there were 20 rounds shot with 2 young men being left for dead in the vehicle. And there was marijuana and money robbed from that vehicle.
Okay, so although this court recognizes that the purpose of bond is not for punishment, we have an extensive pretrial services report that recommends no action. Prosecuting attorney recommends no action. And I'm told that the defendant gave a statement indicating his involvement in this matter, intimately involved in this matter, that the likelihood of conviction is great. So the court is going to deny that request and continue the reading.
Thank you, Your Honor.
Thank you, Judge. Could I take a look at the report just before I push?
Hey, bro.
Judge, if this is concluded, I'll see you at 1:30 this afternoon.
Okay, sir, thank you.
Thank you.
Yeah, I think we're ready.
Yes,
Okay.
Let's start, right? Yes.
Calling case 2356229, Tico State of Michigan versus Michael Angelo Asaro. Defendant is charged in count 1, reckless driving, cause of death. Count 2, failure to stop at scene of accident when it resulted in death. Defendant has been pushed up in the third case notes. Appearances for the record.
Good morning, Your Honor. Sarah Winova on behalf of the people, 84189.
May it please the court, Neighborhood Defender Service of Detroit by Jeffrey Kenneth, E64800 on behalf of Mr. Star. Sir, state your name for the record, please.
Michael Asaro. Date, time set for preliminary examination. Are we ready to proceed?
People are ready to proceed, Your Honor.
We're ready.
How many witnesses will it be?
2, 3 if necessary.
Have any preliminary matters you'd like to deal with before you call witnesses?
Just one, Your Honor. People would move the admission of People's Exhibit 1 of postmortem report under MCL 76611B. We have a stipulation between myself and the defense counsel for exam purposes only for the admittance of People's Exhibit 1 and private identification purposes that the deceased located at the scene, in this case, Danny Vasquez. It's the body that was examined by the medical examiner, again, for exam purposes.
So stipulated.
Yes, Your Honor, for exam purposes.
Proceed that stipulation.
You want me to publish the report?
Yes.
Your Honor, People's Exhibit 1 is titled Postmortem Report from the Office of the Wayne County Medical Examiner. Certifies that Dr. Wynn, Assistant Medical Examiner, performed a postmortem examination on the body of Danny Vasquez at the Wayne County Medical Examiner's Office on September 9th, 2023, with an ME case number of 23-11045. In the summary and opinion portion of this document, it states, it is my opinion that death was caused by multiple injuries in the manner of death of an accident. With that, Your Honor, people are ready to call their first witness.
All right. Who's good?
Your Honor, at this time, people call Jose Morales. He's next.
Sir, please give your name and spelling to the young lady seated there. Your name and the spelling of your name. Please raise your right hand, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Why don't you take the gum out? Okay, keep your voice up nice and loud and speak into that microphone to your left. Swear or affirm to tell, yeah, pull it over. I swear me. Father, you get you raise your right hand one more time. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. You can have a seat. Put the microphone to your mouth and speak into it. You may begin when you're ready.
Thank you. Can you please restate your name again for the record? My name is Jose Morales. Mr. Morales, I want to take you back to September 6th, 2023. Were you at or near Campbell Street and Christian Street? Yes. Is that in the city of Detroit? Yes. County of Wayne? Yes. While at that location, are you on foot or are you in a vehicle? I was in a vehicle into the accident. Okay, and what kind of vehicle is that? I was in a Honda Civic. What color? Black. And how many individuals are in that vehicle? It was me, my wife, my 6-month-old son, and my grandfather. Okay, so 4 total? Yes. And who's driving that vehicle? I was currently driving. Who's your front seat passenger? My wife. What's your wife's name? Eliana Diaz. Can you spell her first name? Is it Illiana? And who is in the back seat directly behind you? My grandfather. What's your grandfather's name? Danny Martinez. And who is in the back seat directly behind your passenger? My son. How old is your son? My son was currently 6 months at the time of the accident. Okay, something happened on that day, the accident that brings your report today? Yes. Okay. Before the accident takes place, where are you traveling? What street are you on? I'm on Campbell. Okay, do you know what direction you're going? No, I was heading to my sister's house. Okay. Campbell, are you coming up to an intersection? Yes. What's the intersection? Christmassy. Okay. And what, if any, observations do you make at that time? Excuse me? What, if any, observations do you make at that time when you're approaching that intersection, right before the accident? Well, right at the corner, there's some apartment buildings. Once I got to the apartment buildings, I hear an engine revving really loud. Okay. Do you look to see where that's coming from? I looked at my mirror and then I looked at my dashboard. I seen I was going 20 miles per hour. Once I looked to the right, the car just came and struck me. He was flying. Okay, when you say that the car just came and struck you, can you describe that vehicle? Well, I was kind of shocked at the moment, so I believe it was a Buick or a Lincoln. Objection to speculation. Said I believe. Just tell me at that time, what did you know for certain? Let's just start with something easy. What color was the vehicle? It was beige. Okay. What other observations did you make about this vehicle specifically at this time? You said the engine was revving? Yes. Well, right before I passed the intersection, I heard an engine revving loud. Okay. And then I looked in my mirror, my rear view mirror, and then when I looked to the right, the car just came and hit me. Okay, when it hits you on the right side? Yes, it hit me on the side of my son, in the passenger rear. Okay. Did you see it stop at a stop sign beforehand? No. Was there a stop sign there? I didn't have a stop sign. He did. When you say he, you pointed to an individual. Was that individual at the scene with you? Yes. Can you state the article of clothing that he's wearing, the individual you just pointed to? He's wearing green right now. Your Honor, may the record reflect identification of the defendant? So noted. Okay. Now, when the police initially asked you who's in the vehicle, what do you say? I currently said that it was me, my son, and my wife. Okay, and what about your grandfather? Well, currently at the moment, I thought he took off running because when I got out the car, there was nobody else in the car except me, my wife, and my son. Okay, how close does your grandfather live to the area? Not even 2 minutes away. Okay. What's your state of mind when you tell the police it's just you and your girlfriend and baby?
Well, at the moment, I was really worried about my son because when I first took him out the car, he was just laying there like something happened to him. And then when I took him out the car seat, I shook him really bad. And I told him, not bad, but I shook him and I told him, yelled his name, and he woke up crying. And he was in shock. He was stuck in a position where he was just crying like this.
Okay, so you had concerns for your 6-month-old child?
Yeah.
Okay. Now, after the accident, do you then observe the other vehicle that's involved?
Yes.
Okay, and do you know at that time what the vehicle is? What kind of vehicle?
It was a Lincoln. Lincoln or a Buick, for sure.
Okay, and what color again?
Beige.
And do you see the driver of that vehicle that you just described?
Yes.
Right after the accident?
Yes.
And that's the individual, is that the individual that you pointed out, and you stated earlier was the driver? Okay. And then describe to me what the defendant's doing.
Well, when he first got out the car, he just got out the car and stared at me. And then he tried walking, because there was a lot of people at the scene. So he tried walking away, trying to leave in the scene without nobody noticing him.
And when we're talking about the scene, is it nighttime, is it daytime?
It was daytime. It was daylight at the scene.
Okay, so do you tell anybody that you observed the defendant trying to leave?
Well, yes, I had told the officer that had came.
Okay, did you point out the individual to
Yes,
the
I had pointed
officers?
him out.
No further questions. Oh, I'm sorry, what was the defendant wearing? Do you remember?
No, I currently do not remember. He hit me so hard.
Okay, no further questions, Judge.
Cross-examine.
Thank you, Your Honor. Mr. Morales, if I ask you a question you don't understand, just let me know.
Okay.
And I'll rephrase. Okay. Mr. Morales, have you been convicted of a crime involving theft or dishonesty in the last 10 years?
No.
Were you using any alcohol on September 6th, 2022?
No.
Any drugs or prescription medication that would affect your memory?
No.
You indicated that your grandfather was behind you, correct?
Yes.
In the car?
Yes.
Okay. And when you got out of the car after the accident, you thought he had taken off running?
Yes.
Okay, or he left?
Yes.
Okay. Did he have a seatbelt on?
Currently, I cannot remember. I don't remember if he had a seatbelt on or not.
What about you? Did you have your seatbelt on?
Yes.
Your wife?
My wife had her seatbelt on and my son.
Was your son strapped in a car seat?
Yes.
You had indicated that your grandfather's house was a short way from.
Yeah, it's literally 2 minutes away.
Okay. How long after the accident did it take for the police to come?
Not even 5 minutes.
Okay. And then you indicated that after the accident, there were a number of people that had come out and were kind of around the area.
Yes, it was everybody, the neighborhood that lives there.
Were there more than 10 people hanging around out there?
Yes.
More than 20?
Yes.
More than 30?
I say it's probably closer to 20 to 30.
20 to 30. Okay, fair enough. And were people upset? Was there yelling? Was there anything along those lines?
Yes.
Okay. Were people yelling at my client?
Yes.
Okay. You said when he first got out of the car, he was looking in your direction, correct? Okay. And then this is when, and at this time, there's this 20 to 30 people are all out around there yelling, correct? Is that a yes? You gotta say it, answer out.
Yes.
Okay. And it was after this and all the yelling that you indicated my client started to walk away, correct?
Yes, he was walking away slowly. He didn't he didn't want to get recognized him walking away.
Well, Your Honor, I'm gonna ask that to be stricken. That's his opinion. That he was walking slowly, he didn't want to get recognized as. So how long after the accident was it that my client started to walk away?
Say probably about 7 to 10 minutes.
Okay, so he was there for about 10 minutes, 7 to 10 minutes. Is that a yes?
Yes.
Okay. And during this time, the 20 to 30 people had come out to the area of the accident.
Yes.
And there was a lot of yelling and accusations made against, is that fair to say? No, no one was saying to him, you caused this accident.
Oh, yeah.
That's what I mean. People were yelling about the accident at him. Yes?
Yes.
Okay. And it was after that that he started to, were the police there when he started to walk away?
No, he already had walked away.
Okay, how far had he gone when the police arrived?
About 1 block
Okay, so he walked about a block away. Which direction did he walk?
towards the freeway, so it would be
Well, let me start. Which street did he walk down?
Campbell.
Okay, so he walked down Campbell did he walk in the same direction that you were traveling on Campbell, correct?
Yes, he was walking the same direction where I was traveling to.
Okay, so as you were traveling, I'm not sure what the direction your car was traveling was the same direction that he was walking? Okay. Nothing further. Can you redirect?
Just briefly, these individuals that are yelling at the scene, are they threatening the defendant, that they're gonna physically harm him in any way?
I'm gonna object this to hearsay. They're asking for out-of-court statement, off with the truth of the matter, sir.
Well, it can be an excited utterance, Your Honor, stating that there's
Yeah,
accidents.
foundation for it.
Okay. When you hear these individuals yelling, how long from the time of the accident do you hear people yelling?
I'm pretty sure about 5 minutes until he left, until he walked away.
Okay, what's the demeanor on the scene? What's everyone's,
Well, I mean, everybody was worried about my son, you know?
Okay.
Like, everybody was just focused on my son, because my son, the way he was, like,
So are there these people that are yelling, are they happy, are they sad?
No, they're sad, they're mad.
Okay. Does anybody physically attack the defendant?
No.
Okay, nothing further.
Can you describe the defendant's demeanor? He said he was looking at you after the accident.
He just looked at me, but he stayed quiet. He was just looking at me like with a mad face.
With a mad face?
Yeah. And when I first got out the car and I looked at him in his eyes, he looked mad.
All right, questions based on my question?
No, Your Honor.
Thank you, sir. You may step.
Your Honor, can I comment on with that?
Please.
Your Honor, this time people call Officer Marcos Rosario.
Sir, please step forward, give your name and spelling to the court reporter. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Thank you, sir. Please have a seat in the witness box next to me. Thank you.
Thank you, Your Honor. Can you please restate your name again for the record?
Marcos Rosario,
And where are you currently employed at?
Detroit Police Department,
For how long?
6 years.
Were you employed in this capacity on September 6th of 2023?
I was,
And were you with a partner on that date?
I was.
What was your partner's name?
Julian Popeye,
Can you spell the last name for me?
POPAJ,
And the first name?
XHULJAN.
Thank you. And were you on foot or scout?
In Scotland.
And did your duties take you to Campbell and Christiansey Street in the city of Detroit, County of Wayne?
Yes.
What brought you to that location?
We got a call for a car accident.
When you make that scene, how many vehicles are on the scene?
2.
And what kind of vehicles were they?
A black Honda and a beige Lincoln.
What kind of damages does the black Honda have?
The rear passenger door side was smashed in and the rear window was busted out. I believe there's a heavy accident there, so.
What about the back windshield?
Back windshield was busted out.
What about the beige, what about the other vehicles? Describe the other vehicles.
It was a 1999 beige Lincoln. It had heavy accident damage to the front of the vehicle.
And where are those vehicles located
They were on the southeast corner of Campbell and Christensen, on Christensen Street on the south side.
Okay. When you first make the location, what if anything happens?
As soon as we arrived on scene, someone pointed out that the driver of the other vehicle was walking down the street.
And
Southbound Campbell.
Where are they walking at?
Southbound Campbell.
Okay. What do you do next?
We approached the person that they had pointed out, and my partner got out and taped him.
This individual, is anyone else around when you observe this individual?
No.
When the individual points at the individual down the street, can you actually see that individual?
Yes.
When you first made contact with this individual, first of all, do you observe anybody in court that was also there?
Yes.
Okay. Can you point to that individual and say something they're wearing?
The defendant in the green outfit.
Your Honor, may the record reflect identification of the defendant?
So noted.
Where is this individual located at on the scene?
On the west side of Campbell and itself.
Is this the individual that you approached first?
Yes.
Okay. Do you notice any injuries on this individual when you approach him? Does he ask for help when you first approach him?
No.
What's his demeanor like?
Well, dismissive.
Calm and dismissive, okay. Did you gather information about the beige Lincoln at the scene?
I did.
Okay, what information did you obtain?
I got the VIN number from the vehicle, and inside the vehicle there was a civil infraction to the registered owner.
Okay, who is the registered owner?
The name on the civil infraction was Michael Asaro, who is the defendant.
Okay. Did you pull a lien on the vehicle?
I did.
Who's the vehicle registered to?
To the defendant.
Now, at this time, when you're obtaining information on the vehicles, do you believe that there's anyone injured at the scene?
Yes, the baby that was in the vehicle.
Okay. Anyone else at that time? Does that change at some point?
Yeah.
Okay. Tell me a little bit about that.
So while we were on scene during the completion of the investigation, a woman yells out that there's somebody.
Objection is to hearsay.
I'll just place the question. Do you obtain information
I
from
do.
this woman? Okay, and with that information, what if anything do you do?
We approached to where she was standing and discovered a person in the bushes in front of her house.
Okay, was this person deceased?
It appeared so.
Okay, and where is this located?
This was on the southeast corner of Campbell Efficiency, right near the accident.
Okay. Did you view video of this incident?
I did.
Your Honor, may I share my screen?
Oh.
Your Honor, people have moved to admit by way of stipulation with defense counsel, People's Exhibit 2.
So stipulate.
So stipulate for example.
And then,
Your Honor, may I publish?
yes.
It's not appearing on the court screen, but it's on mine. Officer, what angle is this video showing us?
This is eastbound Efficiency.
And is this from a house?
Yes,
And where is this house located at in comparison to the intersection?
it would be on the southwest corner.
Okay, so is it a corner house?
Yes.
People are playing the video from 6 seconds to 15 seconds. Stopping the video at 15 seconds. What's the speed limit on Christian Street?
25 miles per hour.
And at the intersection, is there a stop sign for Christian Street? Yeah, people move permit people's exhibit 3 by way of stipulation of defense counsel for exam purposes only.
So stupid.
Inmate?
You're gonna make publish.
Yes.
What street is this that we're looking at?
That is Campbell.
People are playing the video from 50 seconds to 1 minute and 5 seconds. People are stopping at 1 minute and 4 seconds and then replay the video, starting at 50 seconds to 1 minute and 5 seconds. Stopping the video at 1 minute and 5 seconds. I'm gonna play the video, but this time I'm gonna play it at a slower speed. Starting at 50 seconds. Stopping the video at 59 seconds, I would draw the court's attention to the back windshield of the vehicle, the black vehicle. And I'm gonna play pause it until 1 minute and 5 seconds. Stopping the video at 1:05. No further questions.
Cross-examine.
Officer, when you arrived, were there a number of people on scene?
There were.
About how many do you recall?
I had to guess 40.
Okay, so you appear to be somewhere in the area of 40 people or so, by the time you arrived?
Yes.
Okay. Were they all kind of in and around the area where the cars had come to a stop?
All at the intersection, yes.
Okay. And then with all those people there, someone pointed out my client, right?
Yes.
Okay. The people that were there, did they seem concerned, worried?
Yes.
Okay, upset,
Yes.
angry?
Yes.
Okay. Thank you. Nothing further.
Any regret?
No, you're not.
Thank you, sir. You may step.
No further witnesses.
No witness.
Okay. People?
You're gonna. The defendant's charged with reckless driving causing death and failure to stop at the scene when at fault. We heard from the witness first that he's traveling on Campbell in his vehicle with his grandfather, who's deceased at the scene. He observes the defendant run the stop sign, he hears his engine, he defendant actually revving right before impact. He IDs the defendant as exiting the beige Lincoln, staring at him, and then leaving the scene eventually about 7 to 10 minutes later. We next hear from the officer who observes the defendant leaving the scene. When he makes contact with this individual, he's not screaming help, I'm about to be attacked, I'm fearful for my life. He says, I believe he says calm. Calm and dismissive. Not like he just had a mob coming at him with 20 to 30 people and he's fearful of his life. If anything, if you like refresh the scene, please. He doesn't have that reaction. With that, Your Honor, we then see the video, which why I slowed it down so much, because we can see the back windshield, something is jumped out of the back windshield, that would be the deceased, that's how we ended up in the front part of the house. And with that, Your Honor, people are respectfully requesting that the court find it a probable cause on the charges.
We'd object to count 1, no argument. We'd object to count 2 and indicate that, we have somewhere between 20 to 30 people, possibly 40 based on the officer's testimony, that are around the area, that are concerned, that are angry, that are upset about what happened. My client is 1 block away. It's not like he's across the city, he jumped on a bus, he took a cab, he's 1 block away from where there's a mob of 40 plus people that are angry about what just happened. I don't believe that that is sufficient for failure to stop at the scene of an accident. He was there as this crowd grew, he got concerned and he walked a block away. And that's
Tell me why this wouldn't be a question of fact to be determined by a trial.
It very well could be the court's opinion. I just am of the opinion that with what evidence has been presented and the fact that he's 1 block away as opposed to a mile, 3 miles on a bus trying to go to the airport, that there isn't this, and it's not like he was running down the street, that he was really trying to get away. And in the time frame that they had, if he wanted to run, he would have been more than 1 block away.
I don't think the statute says that you have to run.
And I understand, but I think that
stay at the scene of an accident that you're responsible for, that you just caused.
I understand,
I don't know if he was walking away or if he was distancing himself from the crowd that had become somewhat irate, whatever the case may be. That would be a question of fact to be determined by a trial.
Fair enough, Judge.
The court, after hearing the testimony and viewing the people's evidence, is satisfied the people have met their burden of probable cause as relates to the charges contained in the complaint form. The court finds those charges were committed in the city of Detroit. The court finds probable cause committed. Kenneth will be bound over to Wayne County 3rd Circuit Court, Criminal Division for proceedings. Is arraigned on the information date and time of the October 3rd, 2023 at 9:00 a.m.
Your Honor, Mr. Osaro did want to ask if the court would consider a 10% provision onto the current bond.
What is the current bond?
I believe it's $50,000 cash.
Yeah, people would object, the bond was initially 250,000 cash. There was already a bond determination in this case, and it was lowered to $50,000 cash. Now we've held an exam, he's bound over, he's a habitual third. His guidelines put him in prison. It would be 4.8 years to possibly 14.25. We know he led the accident before the caused the bond.
The information said he was convicted of homicide first degree.
There's an issue with that. On his lien, it says homicide first degree, but it said he was sentenced to 7 to 15.
That's not possible.
Correct. So I put that on the habitual because that's what's on the lien. I didn't want to change that. I've been in contact with defense counsel regarding it, trying to obtain more information as to what he was actually convicted of. There was possibly an appeal, from my understanding, that may have taken place, but I don't know.
I did confirm with my client, it was a homicide murder 2nd degree. I think there was just a typo, or when it was entered into the system, it was put in wrong, and if it was initially after a trial, and they said murder 1, I think it's been incorrectly just placed into the
Whatever the
system.
case may be, so we have who stands before me responsible for 2 days. I'm not going to use the bond. I'm not aware of the circumstances that changed since the bond redetermination. So I'll go with the wisdom of that judge who reduced it to the 50,000 cash.
Would Your Honor refer the matter so we can address the issue in circuit court?
I will.
Thank you, Judge.
Yes, sir. So we are at lunch till 1:30. Is that right? No. What's your autopsy report back?
Yes, ma'am. I don't No, because I have. Yes.
There.
Well,
Right. EOI.
Oh, yeah. Yes.
Have a good day, Judge.
Thank you, too.
Have a good day, everyone. Have a good day, Norman.
You as well.
Thank you.
Okay, so lunch till 1:30, folks. Have a great day. Good lunch.
Victims are actually right here.
Okay, so good afternoon again, folks. Okay, there's a lot of you here, and I know in cases like this, emotions run pretty high. But it's very important that you all remain under control. There will be absolutely no disturbances in this courtroom. I don't care whose side of the coin you fall on. If there are any disturbances, then we will see to it that you don't walk out the door that you came in, you're walking outside here. And I don't think anybody wants to do that. So in short, I shouldn't even know that any of you are here in the courtroom. Okay, if for whatever reason you can't control yourself or your emotions, I ask that you excuse yourself at that time. Okay. Can we have the attorneys, please?
Who's your client?
Good morning, Your Honor. Mr. Jenkins.
That's what I know.
Oh, that's the man right there.
Afternoon,
Hey,
Judge.
Mr. Curtis.
My guy up here? Yeah. Is he back here? No, he's all the way in the back. Okay. Let me put it. Keep the eye on me, because I had to keep him separated, so I got him all the way up the back. Hold on. got two RoboCops back there. They don't bring them in. Yeah, they're over in the back. I'm gonna keep them separated. Yeah, yeah. Keep them right here. Yeah. Yes. Council, Judge. Sorry.
I prefer to hold, but if you want me to close this?
Yeah, stay right there. I get, ready, Judge? Yes. Stand behind your attorney. Look forward, look straight. Come on. Don't face backwards, always face the judge. Stand behind your attorney.
All right. Calling case 2358625, people of the state of Michigan versus defendant number 2, Corey D. Jenkins, defendant number 3, Orlando Lowell Giles. Both defendants are charged in count 1, felony murder. Defendant 3 is charged in count 2, felony firearm. Defendant 2 is charged in count 3 felony firearms defense notice. Defendant 2 is charged in count 4 weapons, firearms, possession by felon. Defendant 2 has an additional offender 4th offense notice. Appearances for the record, please.
Good afternoon, Your Honor. John Bell on behalf of the people, P68673.
Good morning, Your Honor, to you and your staff. Brian Berry appearing on behalf of Corey Jenkins, P76788.
And good afternoon, Judge David Cripps, P34972, appearing on behalf of my client, Orlando Lowell Giles, is standing next to me on the court. The defense will make a motion to suppress the witnesses.
All right, ladies and gentlemen in the audience, as well as people out there viewing on YouTube, if you are a witness or potential witness, order you to, if you're on YouTube, to log off at this time. If you're in the courtroom, to step out. If you remain here, you're present during these proceedings, knowing that you are a witness or potential witness, you may prevent yourself from testifying at a later date. How many witnesses do we have?
Your Honor, I anticipate 4 or 5. Relative to the sequestration, I'm just asking that not apply to 33, who's the officer in charge of this.
I have no objection if he's not testifying.
He is,
If he is, then I would ask it.
All right, so can you take him out of order?
I'm sorry?
Can you take him out of order?
I can call him as my second witness.
All right, who's your first witness?
It's going to be Officer Williams.
Do you have any objection?
Same objection.
Okay, so we'll have you step out for the first witness. You have any preliminary matters you'd like to start with before we call the witnesses?
Yes, Your Honor, I believe we have some stipulations to place on the record for preliminary exam purposes only. The identification of the 2 deceased victims in this case, the Martavius Wills and Walter Charles Darth Hagler. In addition, a stipulation as it applies to Mr. Jenkins, who was previously convicted of armed robbery, has not regained the ability or eligibility to possess a firearm.
So stipulated for exam purposes only?
On behalf of Mr. Giles, I will stipulate, for exam purposes only. Your Honor.
For exam purposes, we'll stipulate that there was a prior robbery. I will not stipulate to the fact that his license wasn't restored. I don't know.
Fair enough, armed robbery is specified. And furthermore, Your Honor, we have stipulations to the admission of 2 of the people's exhibits. Exhibit 1, the medical examiner's autopsy report of decedent Martavius Wills. Exhibit number 2, medical examiner autopsy report of Walter Charles Darth Hagler. May I approach?
Yes. These have been administered.
By stipulation, I believe, is that correct?
So stipulated on.
So stipulated, Your Honor.
Stipulated for exam purposes only as to the admission of exhibit 1 and 2.
Court receives stipulations. So,
Your Honor, may I call my first witness?
you may.
I just want to put on the record, I did file a motion to suppress my client's statement prior to the exam. So we can hear that at any time you feel appropriate before the admission of the
Okay, so
client's statement.
ordinarily, those kinds of motions are proper form for those would be over in circuit court if it gets there. But I will take your objections under advisement. I'll hear from the witnesses and I'll judge the evidence as I see it. If what you're saying in your motion is true, that defendant gave a statement about in custody statement that the interrogator was not Mirandized, certainly. All of that stuff will come into play.
Your Honor, to address Mr. Cripps's, I guess, motion and objection when it comes to the testimony regarding the statements from defendant Giles. I will be playing 10 to 15 minutes, which will cover video and audio of the entire Miranda procedure. So the court will see it.
I would ask the court to request it just to hear the Miranda portion and make a ruling on that before we hear any more of the statement.
That's fair.
The 10 to 15 minutes is just the Miranda portion.
Thank you.
Then I'll be moving on to.
Okay.
Thank you.
I'm sorry, to call Officer Williams to the stand and go on the hall.
Sure. Is that you, Mr. Bell?
Yes, Your Honor.
Sir, please give your name and spelling to the court reporter behind you. Please raise your right hand, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? I can't hear you.
Yes, sir.
Thank you, sir. Please have a seat with the witness box next to me. Voice up nice and loud and speak to that microphone to the left. Thank you again when you're ready.
Thank you. Sorry, Officer Williams, can you state your full name and spell it for the record?
Sean Williams, SHAWN,
Thank you. And Officer Williams, where are you currently employed?
I'm sorry,
Where are you currently employed?
Detroit Police Department,
And in what capacity are you employed?
Patrol.
How long have you worked as a police officer with the City of Detroit Police Department?
Since October
Say October 2022?
22. I mean, yeah, 2022. I'm sorry.
Okay. So I just to clarify, October of 2022.
Yes, sir.
Okay. I'm going to direct your attention to August 10th of this year, 2023. Were you working in your capacity as a police officer on August 10th, 2023?
Yes, sir.
Did you have an opportunity to respond to the location at 11343 Pelletier in Detroit, the City of Detroit, Wayne County, State of Michigan?
On my report, I have 1132.
Is that
Another date.
why did you, let me ask you this, what time did you respond to that location?
I'm not sure of what time.
Do you know approximately what time?
The city wasn't sure.
No, sir.
Yes, and answer.
Different question.
Why did you respond to that location, Officer Williams?
Judge, maybe have to put down the report and then just refer to it and when the
Yes, you have to make the report down, sir. If you need to refresh your recollection, let us know, then you can refer to it.
Okay.
So, Officer Williams, why did you respond to the location at Pelletier, Detroit, Wayne County, State of Michigan?
I was on a shots fired police round.
When you responded, did you locate a specific vehicle?
Yes, sir.
What was the make and model of that vehicle?
It was a Chevy Malibu.
What color?
Can I refer to black?
Black.
Black color.
And did you locate any individuals inside that vehicle?
Yes, sir.
How many individuals?
2.
You arrived where either of those individuals responsive?
No, sir.
Okay. Did you look inside the vehicle, the Chevy Malibu?
Yes, sir.
Did you observe any firearms in the vehicle?
No, sir.
Did you observe any weapons in the vehicle?
No, sir.
And what did you do after you arrived?
After I arrived, I observed the individuals and my partner requested EMS.
And did you stand by and secure the scene?
Yes, sir.
I'm going to show you on the screen just briefly. People's proposed exhibit number 4.
They asked why it's being produced. That impeachment of the Russian memory.
just a photograph of the scene.
What's your objection?
I just didn't know what it was. I didn't
Oh,
have it there.
here, right now.
It's just one photograph. That's it.
Officer Williams, can you see People's Proposed Exhibit number 4 on the screen?
Yes, sir.
Does that photograph appropriately indicate what you used to observe when you arrived on scene?
Yes, sir.
The location of the bodies in that scene location when you arrived on scene?
Yes, sir.
And I'm moving for the admission of People's Exhibit 4.
No objection, exam purposes only, Your Honor.
For exam purposes, admitted.
Thank you, Officer Williams. Your Honor, I don't have any further questions for this witness at this time.
Cross exam.
Thank you. Officer, you've been referring to a report you have in your possession, is that correct?
Yes, sir.
Is that your report?
Yes, sir.
Can I see it, Your Honor? You talked about responding to a shot spotter, is that what you called it?
Yes, sir.
Okay. And did you yourself receive that information, or was it some other police officer?
It was dispatched to us.
All right, so you received a dispatch, is that correct?
Yes, sir.
And a dispatch just sent you to a particular location, is that right?
Yes, sir.
You had no personal knowledge of the shot spotter itself. You just responded with the dispatch call, is that correct?
Well, what do you mean by that?
Or did you receive personal information other than this dispatch regarding the shot spotter?
Yes, sir. It's shots fired.
Yes, it was a shots fired run, is that correct?
Shots fired.
Okay, and shots fired, call, you didn't get a specific location to go to, is that correct?
The location that's listed on my report, that's the location that was given.
Okay, so that's why you went to that location, you corrected the prosecutor as to the exact location, is that right?
Yes, sir.
Okay. And were you the driver of the police car or the passenger?
I was the passenger.
And there were just the two of you and Officer Jones, is that right?
Yes, sir.
And when you arrived at that location, you saw nobody outside the car, is that correct?
Just two individuals that were in the car, that's all I saw.
Well, when I asked you, did you see anybody outside?
Nobody else.
And we saw a photograph up there. Did you take that photograph?
No, sir.
Did you see anybody else take that photograph?
No, sir.
So it's something that was done after your arrival, then, is that correct?
You go with that question again, sir?
Well, it either was taken before you arrived or after you left, because you didn't see the photograph taken yourself, is that correct?
Yes, sir.
Right. When you, was the door open, as we saw in exhibit number 4?
Which door are you referring to?
The photograph itself, I saw one of the doors.
The passenger door was open now.
Oh, it was open when you arrived, is that correct?
Yes, sir.
All right. Now, did you go and search the car itself?
No, sir.
So there could have been guns inside the car, you don't know because you didn't search it, is that correct?
I did not search the car.
So that you didn't know if there were guns inside that car or not, is that correct?
I don't know if there's, okay.
Right, that's what I'm asking. You wouldn't know because you didn't search the car, whether there was guns in it, right?
Yes, sir.
Thank you. Did you take anything in the evidence, officer?
I put the car on it.
Which car was that?
That would be the car that the deceased in.
Anything else other than that?
No, sir.
Thank you. I don't have any further questions.
Mayor? You arrived, were there any other officers at the scene?
Yes, sir.
Who was there?
There were a few ops units.
That were there prior to your arrival?
No, sir.
Were you the first on the scene?
Yes, sir.
Thank you. I have nothing further.
No, Your Honor, may this witness be excused?
Yes, sir, you may step down.
Or, if I may call Sergeant Reed to the stand.
Sorry, what did you say?
Sergeant Reed.
Please give your name and spelling to the court report, Sergeant Reed. Give your name and spelling to the court report. Okay. Raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat with this spot. Thank you, you're ready.
Thank you, Your Honor. Good afternoon, Sergeant Reed.
Good afternoon.
May I ask that you spell your full name for the record?
Jabaris, Jabaris, Reed, R-E.
Thank you. All right, Sergeant Reed, where are you currently employed?
Detroit Police Department homicide section.
And in what capacity are you employed?
Sergeant with the homicide.
Thank you. How long have you worked as either a police officer or sergeant in the homicide unit for the Detroit Police Department?
Close to 20 years.
20 years. Were you working in your capacity as an officer, sergeant, regarding the dates of August 10th and a few days after August 10th, 2023?
Yes.
Just want to briefly ask you this case regarding People versus Washington, Jenkins and Giles. Are you the officer in charge of the case?
Yes.
Can you briefly identify for what officer in charge means?
So officer in charge means I am responsible for collecting all the evidence, going through the file, put together an investigative report and submit it to the courts for charging decisions.
And is part of your duties to oversee all the evidence in the case?
Yes.
I want to direct your attention specifically to an individual by the name of Corey Jenkins. Do you know the defendant Corey Jenkins in this case?
Yes.
And you point to him, identify what he's wearing?
He has longer dreads, black male sitting behind the defendant to the, will be my right.
Your Honor, may the record reflect the witnesses identifying defendant Corey Jenkins.
So,
thank you. Sergeant Reed, get right to the point. Your investigation in this case was Mr. Jenkins taken into custody?
Yes.
And when he was taken into custody, did you have an opportunity to question him?
Yes.
Prior to questioning him, did you advise Mr. Jenkins of his Miranda rights?
Yeah, I was in the room when he was advised of his rights.
And what was said to Mr. Jenkins regarding his Miranda rights?
So we
I'm sorry, I didn't hear who said that.
Here's.
As far as what was said to.
What was said to him or
Mr. Jenkins' statement to it here, sir.
Correct.
Rephrase your question.
Sure. Well, let me ask you this, was he advised of his Miranda rights?
Yes.
And how did Mr. Jenkins respond?
He signed, his rights as they talked to us.
When you say he signed his rights, was he given a Miranda form?
Yes.
And what were the rights listed on that form?
I have to read them to you. It's like a right to remain silent, not to answer any questions put to you. Paraphrasing, that attorney, if you cannot afford an attorney, won't be appointed for you. And that you free and voluntarily want to give a date.
Did Mr. Jenkins initial each one of those rights?
Yes.
Did he sign the Miranda waiver form?
Yes.
And you stated he agreed to speak to you?
Yes.
Now, did you question him specifically regarding the deaths of Octavius Wills and Walter Charles Garth Taylor?
Yes.
Regarding those deaths, did you question him regarding the date of August 10th, 2023?
Your Honor, I would object on behalf of Mr. Giles to the admission of any statement made by the co-defendant against the case against Mr. Giles.
I understand how that goes.
Yeah, I'm not asking the court to consider.
Against your client. The court won't consider the statement that co-defendant made towards your client.
Thank you. I'm sorry, Sergeant Reed.
Yes.
Regarding the deaths of Martavius Willis and Walter Charles Garth Taylor, as the officer charged with the case, what was the location of their deaths?
11343 Delaware.
And that's in the city of Detroit, Wayne County, state of Michigan.
Yes.
Specifically regarding the homicide, Mr. Wills, Mr. Garth Taylor, did Mr. Jenkins state whether he was at the scene at the time of the shooting?
Yes.
What specifically did Mr. Jenkins say?
What's the objection? Straight objection.
What did Mr. Jenkins state to you regarding his being at the scene?
He drove to the scene. His phone was used during to get the individual there to commit the robbery. He knew the robbery before they got to the scene. After they left, he drove away, and he, I think, say took some of the weed or took something from out the bag, or they split stuff up or something of that nature.
Okay, let me back.
Objection to speculation.
Let me back up to this.
You need to strike that.
Not speculation.
He says, I believe, he's not very certain as to what he said.
I'll take the testimony as it's given.
I'm sorry, Mr. Sergeant Reed. Let me back up a little bit. You stated Mr. Jenkins stated his phone was left at the scene?
Yes.
Was the phone recovered from the scene?
Yes.
Did you have an opportunity to review that phone?
Yes.
The same phone that Mr. Jenkins told you was left at his phone that was left at the scene?
Yes.
Were there any communications between Mr. Jenkins' phone and the victims in this case?
And I'm objecting to this, Your Honor. This is beyond the scope of just asking what Mr. Jenkins said. Now he's asking about some physical evidence that I would object to. Well, it sounds like he's testifying to something that was on the phone as opposed to what was said to him.
So what's your objection?
Objection is there's no foundation for any of this.
Your Honor, this is a conversation that he had with Mr. Jenkins and information that was relayed on that phone.
But that's what I said. If he's saying, if your sergeant is saying this is what was told to me by Mr. Jenkins, I have no objection, as opposed to it sounded like he was going into what was actually physically found on the phone.
So your objection is best evidence.
Absolutely.
Your Honor, this testimony doesn't contain versus fine.
Well, I'll join in the objection that's hearsay.
If he's going to be trying, he's telling us what's on the phone, then the best evidence would be the phone itself, what was contained in the phone, not his interpretation as well as.
I understand. It was a conversation that we had with Mr. Jenkins. I'll withdraw that question. Let me just, give me 1 second, Your Honor. Sergeant Reed, was your interview with Mr. Jenkins, where did it take place?
Detroit Police Headquarters.
Was that audio and visually recorded?
Yes.
In what room of Detroit headquarters did that take place?
I don't remember the exact one, but we got it, we saved it.
Sergeant Reed, can you see People's Proposed Exhibit number 6 on the screen?
Yes.
Can you identify to the court what that is?
That's our interrogation room.
Great. Who is this individual right here?
That is Mr. Jenkins.
Lieutenant Jenkins?
Yes.
Okay. Who is this individual right here?
Lieutenant Bray.
What was that last name?
Bray.
And who is this individual right here?
Myself.
Was this video accurately portrayed the interrogation of Mr. Jenkins?
Yes.
Your Honor, we're moving for the admission of People's Exhibit number 6.
Any objections?
For purposes of exam, no objection.
Admitted.
Sir, if I may, I'm skipping ahead to 5:09 and 52 seconds into the video. Play an easy portion for the court.
Yeah, so it had to be like earlier that day with them. I don't know. Did they have any leave? Yeah. Or they drink it all? They drunk it all. Man, like they better get some more and shit. They high as hell? Okay. What Coney Island? The one on Joy Road, he said. Was that Joy, Dexter? Joy and Dexter. Oh, the gas station, Coney Island, liquor store, and the strip mall? One-stop shop. One stop. It was all 4 corners. All 4. What kind of car does Jordan got? Hey, I don't got no car. He ain't got no car? He ain't got no car. His cousin, friend, what the fuck that nigga is, he supposed to have a car like a little, I don't even know. It's just a little car he's saying. That bitch, I don't know what kind of car it is, bro. You gotta ask him. I don't know. Mm-hmm. Oh, God.
So I need to know what the plan was. That's what I need to know.
There wasn't no plan. Nigga just told me to pull up.
They told you to pull up on them?
Yeah. We gotta go throw dice or something? Or?
For what purpose?
No, it's not like I don't be fucking with the nigga, you know what I'm saying? From time to time, you know what I'm saying? You pull up to come sit over there. And chill, you feel what I'm saying? It ain't like I don't be fucking with, you feel me? His brother locked up, you feel me? That's my man, you know? That's how me and him got to deal with each other through his brother. You know what I'm saying? Did you know he had a gun? Why, he always got that gun with him? Nigga, fucking gun. The same gun, or different gun? Yeah, he be having different guns. Sometimes same gun, he be having different guns. When I see them, every time I see them, he only had like 2 different guns. And they be hand pistols.
You said you had weed on you, and they were going. They said, "Let's go get some weed."
Yeah, I had like, I probably had like under an ounce.
Right. So there was no reason to go get no weed from them guys.
Exactly. I'm like,
so
we didn't go nowhere.
That would use.
No, I understand that. What I'm saying is, you weren't standing next to each other initially when they made this decision. You weren't standing with them other guys when they made that decision, right?
Right.
Right. So, when they say, let's go get some weed from them guys, you are telling my guy.
I already got weed.
Yeah,
I don't want none of that bullshit.
Yeah.
Oh my God.
So,
but I'm rolling it up.
Here's what Jordan says. I'm just telling you what Jordan says. Don't fucking get mad at me.
Go ahead.
I'll tell you what Jordan says. Jordan says, you guys talked about this, that you guys were not you, were gonna do the robbery. They were gonna rob them guys. You was gonna drive them up out of there. That's what he says, okay? Then he also says that when the shit got bad, you did the shooting. I don't believe that shit. Now, hold on. I don't believe that shit.
Motherfucker, trying to sell us
You know what I definitely believe him about? I definitely believe about the conversation about robbing him. That I for sure believe.
No, listen.
You a regular lick hitter from Bavaria past. You already told me that earlier.
That shit was, no, I'm 33. I'm 32, might be 33, bro. I sell dope and weed.
I know.
What? I ain't robbing, nigga. The probably heard of my squad back in the day. NBC, we was the young niggas doing that. That's back in 06, 05, 07. We did that shit. Most everybody still locked up from that shit.
Mm-hmm. Well, here's where we're at, man. You drove him there, and you drove him away from there.
I did that. I can't lie. I did drive him there and did drive away, but not knowing that was finna happen, intentionally not knowing.
You knew that was gonna happen. 100% you did.
Okay.
What time did you pick him up and drive him over there?
I don't even remember.
You picked him up from his house, or you picked him? Where you picked him up?
Yeah.
You picked him up from his house? How long did it take y'all to get? Were y'all driving around?
No, we was driving around.
How long?
We was driving around for probably 40 minutes, and we put up on Belltail on the other side, chilling and shit, you feel me?
How long y'all chilling there before you say we're gonna call these guys over here?
I didn't say I'm calling nobody.
Listen, I didn't say you did. How long before y'all said that y'all were gonna call these guys?
We was chilling.
How long were y'all at Belltail before y'all said, hey, let's call these guys over there to buy some weed? And leave?
About
hour, 2 hours?
No, hell no. Probably about no more than, I'm gonna say no more than, before they called me, no more than 30 minutes. 45, some shit, probably like that.
30, 45 minutes.
Probably some shit. Probably not 45.
How long did it take for the guys to get there after they sent the messages?
Shit, it took the niggas a little minute.
Okay. And then you said then they started calling your phone?
The nigga, no, this one, Jordan was calling them, and then they send the location and shit. They about to get some weed, so they sent them the location. And then the niggas pulled up. They went over there. I'm still rolling up. They went over there.
Okay. Did those guys drive off after the shooting?
Who?
The people that got shot. The people that got shot outside of Belltail.
I can't tell you if they pulled off.
Okay. What did you see as you were driving off?
No.
Did you see brake lights on?
Yeah, brake lights was on.
Okay, but you didn't see the car moving now. Okay. And you didn't hear nobody else shooting?
I just heard gunshots.
I'm saying, but you didn't hear nobody shooting at your car? There were no bullet holes in your car?
No.
Okay, so nobody shot back at your car?
No.
Okay. But you don't know what these guys look like?
Honestly, don't even know what the fuck they look like.
But you ain't go try to see what kind of weed they got?
I don't know what they look like or none of that.
Okay. I mean, when you smoking, somebody else tell you some weed, you like shit.
But that's them niggas going, you feel me, going to get their weed. I got weed. You know what I'm saying? I got an ounce or under an ounce. I'm not going over there. I don't even know them fucking people, so I'm not going over there. You know what I'm saying? But I'm here with y'all, whatever. You know? But you know what I'm saying? I'm here with y'all, whatever. Whatever y'all want to talk about, I'm here. You feel me? Because that nigga tweaking. If he in there for real saying that shit, I ain't no motherfucker going, listen, bro. I done did some shit in my past, but that ain't that one of them.
Yeah, and we don't
I done did a lot of shit, but that ain't one of them.
And we don't believe you were the shooter, but you definitely participated in a robbery. That's the problem.
Not knowing allegedly what the fuck was really finna happen.
You did. That's the difference.
Okay.
That's what I'm trying to get you to understand.
We gotta make sense of it's
scenario.
Yeah.
Come on, this police shit. I know y'all gotta make sense. It gotta make sense to y'all. Gotta make sense to everybody.
That's why I'm being such a pain in the ass about this.
No, you not. It just, I'm cold.
Does it not make sense?
Yeah, it's getting a little warm.
It don't make sense to you either, do it?
Your phone.
No. If I was in your shoes, hearing this shit, it wouldn't. I'm telling you, I'm being honest. I would've been like, no.
You see how you already mix?
Yeah.
Your phone
put me all the way in everything.
Your phone, not nobody else's.
My phone.
Your phone is left there. Your phone is used to get them over there to Bellettier. You send the address from your phone to them on their phone.
No, I ain't saying shit.
Whoever had your phone number, the phone that's left,
yeah,
send him the address. So it's almost like he left it there on purpose.
Really, no.
To get you in the mix.
Cause that won't make no sense. You're right. Right? Yeah, you're right.
Okay. He went to you to get his phone. Use your phone. And he been talking to the dude already.
Yeah. But me, being so dumb, not even thinking like that.
Hey man,
I'm not even thinking.
He already talked to the dude already, and all of a sudden he went to use your phone. And I'm sorry, bro. I know you may be all, believing people and shit. But one thing I do know is they didn't remember his number like that. That's not it. Just like you got two phones.
Oh, I don't know them niggas.
No, I didn't say you did.
Yeah.
I know for a fact he don't remember people's numbers like that.
1000%.
I can get, listen, they got it from another phone.
Yeah, but I'm telling you, they call, I don't know. They
listen, I hear you, you're not even listening.
No, I'm saying what you're saying. They got another phone because he don't remember. I understand.
No, you're not even hearing me.
No.
How you getting played from the beginning?
Go ahead.
You missed it. I sent it over there and you missed it.
What you saying?
They got phones. Actually, I know they got phones on them at the time.
Huh.
All that technology shit in the air. I already got I already know where they at. Their phone in their pocket. But they use your phone to call him.
Yeah.
And text him the address off of your phone.
And leave my phone.
And make you the heavy.
Like,
and then you drive off with them
and take him home.
When did he tell you he left your phone there?
Huh?
Did he tell you in the car he left your phone? He left your phone there? When did you find out this motherfucker left my phone?
I dropped them. I'm like, where my phone at? He looking for it. I'm like, where my phone at? He like, I dropped your phone. I'm like, what? Fuck you mean you dropped my phone? You feel me? So when that call, I dropped him off, I dipped, boom. I call my baby, I'm like, I need you to take me to get my phone and shit, you feel me? Before you go to work. She like, what you mean? Like, I need you to go take me to get my phone and shit. She like, alright, you feel me? I'll come get you before I go to work and shit. You
didn't tell her why you left your phone somewhere?
No, I didn't tell her.
The police wasn't over there when you got over there?
No.
Can't ask no questions either, huh?
She definitely asked, but
you ain't say shit, huh? Okay.
Do you understand that there's a difference between orchestrating a robbery or being a mere participant in a robbery? Do you understand the difference between that? Or do you want me to explain it to you?
Orchestrating a robbery is you planning, you knowing what's going on, you're a part of everything, and you're
in charge of it.
Yeah, you're in charge of it. And then you say what else you say?
Participating
and being a part of something, or being around, or being present, or being active in a situation, right?
We're close.
Something like that.
So here's what I know happened. No matter what he says, I know you didn't orchestrate the robbery. but I know you participated in the robbery. Okay?
By dropping them off and shit.
Yeah. Well, that's one. Dropping them off, right? At that point, you had knew that they had robbed him, right?
Shit, that's when they got in the car with this shit.
Hold on. See what I got to say.
Go ahead.
At that point, you knew that they had robbed him, right? Because you told me he came back to the car with a gun in his hand and he had a QP on him, right?
Yeah.
So at that point, you knew that they robbed him, right?
Right.
And then what did you do?
I dropped their ass off.
So what is that?
That make me a part of it.
Do you think that makes you a participant in a robbery? Yes or no?
Yeah.
Yes or no?
Yeah.
Okay. Okay. So we got that out the way. You participated in a robbery.
That's on what you charged.
No, we ain't.
For these niggas.
We ain't there yet. I need to know what he's putting in, making you the heavy. You know what that means? Being the heavy. He making you the guy.
Right.
Okay. So I need to refute that with information out of your brain right there.
Right.
I need you to tell me what he said about hitting this lick beforehand. Because if he is the mastermind, I need to know that. You're already a participant in a robbery. I need to know the discussion between you guys and what was said. And I know there was one. That's not a question. Tell me what this man said.
I'm telling you what he told me, bro.
Tell me what he told
me. That's hearsay. I object to claiming the man said is, even if it comes from my client.
Not if it's coming from your client.
But he's talking about what somebody else said.
I understand that. Overruled. May proceed.
Thank you.
And then what did he say to do?
When he pulled, I pulled up on him and shit. They hop in the car and shit, like pull off his shit, you feel me? So I pull off. We riding around, we in corn. They not talking about nothing at that time, you feel me? Because I'm steady watching this nigga in my back seat. I don't know this nigga.
Okay, so they're not talking about it at that time. Okay, what goes on there?
You know what I'm saying? So we riding, so I pull up on the block and show my pull right here and shit, you feel me? So I'm chill, because you know, that's me just keep riding, wasting gas, you feel me? So we pull over and shit, you feel what I'm saying? Like I told you, we chilling. Trying to smoke the blunt, you know what I'm saying? We smoked it was a little piece when we smoked in rolling up a little fatty doobie. You feel me? They like that weed bullshit. Ooh, they about to call get some weed. I'm like, I got weed. You know what I'm saying? I'm like, I got weed and shit. All that shit, some bullshit. I'm laughing and shit like, you feel me? I'm about to call my man, so I got some weed to leave from earlier. I'm like, all right, let me see your phone. I get a nigga phone. I'm not thinking nothing of it at that time. Honestly.
When does he talk to you about robbing the guy? That's what I need to know. That's what I need to know. I need to know it bad, bro.
I know you do. I know you do. And I believe you. But I'm trying to tell you, I'm no mess around, and this is what's going on, bro. If you go through my phone, bro. You will see this shit, bro. I'm trying to tell you. I ain't got. And I feel like y'all not believing me.
So you're sticking with the only participation you did in the robbery was driving him off. Is that correct?
No, I'm saying I knew I drove him off and shit. You feel what I'm saying? After that shit, yes, I did. Like, I'm trying to understand, like, what is?
He's saying that there was a discussion. We've already established that you participated in a robbery. You and me both have established that. The fact that you drove them off from the robbery, when they came back to the vehicle, you knew that they had robbed them. They had a gun in their hand. They had a QP. We've already talked about that. I'm good with that.
Yeah, I ain't gonna lie.
I'm good with that. Listen, hold on. I'm good with that.
I understand.
Beforehand, he's saying there was a conversation. He's saying that you planned the robbery. You're saying that you didn't know nothing about it. I need to know what that man said.
I don't even know them niggas.
That don't matter.
How?
You can still have a discussion. If me and him are going to go rob somebody, and I don't know the people, but he's the one that's setting them up, right? I don't need to know them. We can still have a conversation about what's going to happen. He's saying that you set it up. I believe you that he set it up, but I need to hear the conversation that y'all had about it prior to the incident. Because I know, just like you said earlier, shit don't make sense. So I know when shit don't make sense, it ain't true. So I know there was a conversation prior to hand. It doesn't make it anything any better or any worse for you.
And
You're already a participant in a robbery.
okay, I just put myself in a position of robbery.
Oh no, your man put you in there. You didn't put yourself there.
So
Your man that text the address, left your phone at the scene, that you took home, put you in the position that you're in right now. You see what I'm saying? This ain't no like, oh, just grab some shit out the sky, we just making some shit up. You feel where I'm coming from? You got put all the way in the game.
So tell me what the discussion was. That's the biggest thing, and then I stop fucking being such a pain in the ass, man. I'm just trying to.
No, you ain't getting no pain in my ass. No, I understand. You doing what you're supposed to do. I feel you. I told y'all I've been through this shit, man.
So tell me about the discussion.
So
tell me about the discussion. That's what I want to know. And then we can move on from this, bro.
That was a discussion.
What was it? Say it.
All right, look. I'm not about to bullshit with y'all. I ain't about to play with y'all. I'm done, because I already see I'm about to get locked up anyway for some shit. But I'm about to get locked up for murder.
So you don't want to discuss the fact that he's saying something that completely makes you look way worse? You don't want to discuss that?
No, I'm not saying that. No,
that's what I'm. You ain't hearing what I'm saying. All I want to know is he's saying that you planned it.
This
if
what
he
happened.
planned it.
I'm done. I'm done.
Okay.
This was going on.
Okay.
I'm gonna object. Further play.
No, he said he's done with the. Oh, you want to? No. I think it is he's done talking to me. Miscommunication. That was my bad. That's my.
I'm sorry.
Okay, so he says I'm done, but what does that mean?
Well, he's saying, I'm done talking. That's it. I'm done.
And you listen to 10 seconds, well, maybe the next 20 seconds of the video, the detectives are saying, okay, you're done, we're done here. And it's the defendant saying, no. What he's referring to as far as I'm done, which I think the quote here is he's done in the case, like he's gonna tell the detectives what actually occurred, not he's done with the interview. He even says, no, and the detectives are gonna say, oh, so we're done here? So he's not, the court has to listen to.
He's expressly indicating that he doesn't want to talk. I'm done. From there,
Well, let me
they
see
need
what
to,
happens then.
but they need to stop. And even if
But I don't know if they did or not.
Even
or
if
he initiated further conversation.
even if he initiates, there should be a waiting period, and then they should come back in.
Show me that in the law where it says it's.
And they should come back in and read them his rights over again.
No, sir, that is not the law. That is not the state of the law.
Judge, all questioning should stop right when he says that he's exercising.
And I don't know if he did or not because he stopped.
Okay.
I'm gonna back it up just a little bit.
I'm gonna ask the court to continue my objection.
So the court can hear exactly what the defendant said right after he said, I'm done. And the detectives wanted to stop. The defendant was saying, oh, no.
Anyway, for some shit. But I'm about to get locked up for murder.
So you don't want to discuss the fact that he's saying something that completely makes you look way worse? You don't want to discuss that?
No, I'm not saying that. No,
that's what you ain't hearing what I'm saying. All I want to know is he's saying that you planned it.
This is what happened. I'm done.
Okay.
This was going on.
Okay. Cool.
We're gonna have to go with what he's talking about.
No, he says
I'm done.
Oh, you no. I think it is you said you was done talking to me. Miscommunication. That was my bad. That's my fault. Come on.
Man, my God, but this is going on. Listen, bro. Before I say anything, y'all gotta give me y'all word y'all gonna know that y'all ain't gonna be able to do it, but y'all gonna have to figure it out.
Taking care of your daughter? I got you. I give you that word as my man.
They got, it's, bro, y'all don't understand. That's what I'm trying to tell you.
I don't want a little girl getting hurt. I got you. I got you.
They don't care. Them niggas don't care, bro. Niggas don't care, bro. They don't care about me. They don't care about my kid. They don't care about nobody. I gotta make sure my girl's safe, no matter what.
I got you. That ain't no bullshit. I got you.
For real, bro.
Big dog. Right here.
No,
I got you.
You too, bro.
I'm with you. I'm with you.
Alright, fuck this shit. Oh, this is what happened, bro. Nigga called me and shit. I pull up and shit, you feel me? We riding and shit, he politicking and shit with me and shit, me and him and the other nigga. I keep watching the other nigga, cause I don't know this nigga, dog. They both got guns on them, I don't know this nigga and shit, you feel me? I fuck with him a little bit, you know what I'm saying, nothing like that, cause me and him scrapped too, you feel me, a couple months ago, so it ain't like that. But anyways, so we riding, he like shit, I just bought some weed and lean from a nigga and shit, you feel what I'm saying? Me and Cuz about to rob them niggas and shit. So this how this shit come about on Bellaterra. But when they talk about that shit, I'll pull up over that bitch and shit. Cause this was the block we all on. We pull up and shit, you feel what I'm saying? So they keep telling my man, fuck that shit. Ooh, you feel what I'm saying? We can get a bag, good enough. But anyways.
This is we gonna rob them and get a bag?
Yeah.
Okay.
But anyways, so I'm like, listen, bro. I'm like, fuck all that shit. Ooh. Nigga, I'm not thinking about none of that shit. You feel me? So as they going over there to go get the weed or whatever, they had to use my phone. You feel me? They didn't have no phone with them, bro.
Mm-hmm.
They didn't have no phone with them, bro. You said they phones there. They did not have no phone with them, bro.
Okay.
That nigga used my phone. They did not have no phone.
They call a piece of paper with his number on it or shit?
No. When I tell you,
we good with that. They went over. They talked about robbing them. Is that I'm not understanding you correctly?
They talking about hitting the legs, robbing niggas. You feel me saying? So this one I'm pulling up. You feel me saying? This one we talking about that shit. So we get out of my car and shit. You feel me? We sitting on the porch and shit. I'm rolling up and shit. We just got on smoking a little piece of one. I'm rolling up and shit. They keep talking about weed ass and shit. Ooh. So they calling them and shit. I keep telling my man, fuck that shit. Ooh. So the dog end up calling back and feeling like saying the address. So they sent the address and shit, you feel me? Boom. He gave me my phone back and shit. I'm not thinking none of ooh, boom. Dog call. Give him the phone. I'm like, huh? Your people's calling. Yeah, since people's dog was calling, they was hitting the quarter. So they hit the quarter. They walked down there. And they hit the quarter. At time it comes to the house where we was at. And we getting the address on. They walking down there. I'm still on the porch. You know what I'm saying? I'm still on the fucking porch. I just hear them talking. And then I just hear a shot. I take off. I'm in my car. By the time I start my car up, Doug jump in my shit. First thing I see is the fucking gun and shit. You feel what I'm saying? Mm-hmm. I nigga pull up. So I pull off. I drop them niggas off. I ask on my phone that. He like, oh, it's in the car. Ooh, it's not in the car. He like, I must have dropped it. Ooh. So I'm like, I'm gonna go get my phone. He like, nigga, don't go back over there. I'm like, I'm going to get my phone. I'm telling you, I'm going to get my phone. So I call my baby mom and shit like, can you come take me go get my phone before you go to work? Woo. She like, all right, woo. She not knowing what the fuck going on. You know what I'm saying? Mm-hmm. She like, what's your phone on? I'm like, I left my shit over here. Shit, woo. So I go over there. The phone not there. You know what I'm saying? I don't know. The phone not there. We leave. They call me the next day. You feel what I'm saying? We chopped up the next day and shit. I'm like, what's up? You feel what I'm saying? I'm like, how you feeling? Because in my mind, you kill somebody, you're going to feel a type of way. You're going to feel something. So I'm trying to figure out how you feeling. You feel me?
Because in your mind, you guys are just trying to rob them.
That's what their whole plan was, I guess. You feel me? I wasn't.
Hold on. Not that you guess.
Yeah,
You guys talked about it beforehand. That was the plan, was to rob them.
They say he was going to rob some niggas. You feel me? Had to like, boom, all right.
Beforehand, right? Before they said they were going to go rob somebody before you all were sitting on the porch and all this other shit happened, right?
Yeah, when they was in the car and shit, told me they want to rob a nigga. Feel what I'm saying?
All right.
Now, boom. Now we get there, I'm like, rob who? Boom. I'm like, niggas just served us at the Coney Island. So we
Hold on, so I don't mean to keep interrupting you, but I'm trying to hear it. My hearing ain't great. So you said rob who? And they said we gonna rob the
niggas. So we just got some weed and lean from
and
her.
You said okay, right?
I'm like, all right. Shit, they ain't got nothing to do with me. You feel me? But this was earlier. You know what I'm saying? This was earlier around the time. It was still light time. You feel me? Around this time. Mm-hmm. You know what I'm saying? Not light, but not dark. Okay. You feel me? So, boom, I'm pulling on the tier and shit. I told you, Rob, we over there for like 20, 30 minutes and shit, you feel me? We over there just chilling, chopping up and shit, you feel what I'm saying? Nigga asked for my phone. I give it to him. That's the honest truth.
Because they were trying to give these guys the location?
Yeah. But...
So you gave them the phone.
They said they ain't had their phone on them.
Right, no, I got you. I ain't mad at you. You gave them your phone so that they could give these guys the location of where y'all were at.
Yeah, I'm not thinking nothing of it. Like, you know what I'm saying?
Well, you knew he was going to rob them.
Yes or no? The rob the guys with this pussy.
Yes or no? You knew he was going to rob them, right?
I know they wanted to rob me, yes.
Okay. All right. We're so much better now.
We've been better. So, that's what he was saying.
Yeah. So, you knew when they made that phone call on your phone, they about to rob the guys if they pull up. Mm-hmm. Yeah, they just took longer than expected.
Yeah, that's why he had to give me the address.
I didn't give him that.
That's right, not you. You had to give them the phone for them to give the address so that they would come over there.
No, they asked me to use my phone.
So they're giving to give them the location.
Yeah, I ain't know. It was about to look. They like, let me use your phone so I can call a dog for the weed and shit. Ooh, we about to grab some weed and shit. You feel me?
Yeah, because you guys are going to rob them.
You know what I'm saying?
Because they got to get to them.
I'll be right back.
I guess.
Keep going, bro. I'll be right back.
You know what I'm saying? See, he keep throwing me off. He keep throwing me off, man. He keep making it seem like it's me.
No, we ain't saying it's you. We're just saying we're just trying to figure out something. We're trying to eliminate this motherfucker from lying to me. You know what I'm saying? I know the motherfucker lying to me. You ain't been doing it.
I'm telling you, I'm just worried about my daughter, bro.
So, and they called him on your phone after they discussed that they wanted to rob the dude that they bought lean and weed from.
He gave me my phone back.
Now, if you wasn't with him when they bought lean and weed from him.
No, I was not.
Okay. Because you said it's from Dirt Road, Coney Island.
Yeah, he said they had met him. This was like Coney Island on Joy Road and shit earlier or some shit.
You tell me what time?
I don't know what time niggas.
So if I went there and got video, I won't see you.
Yeah, you ain't gonna see me.
When if I see the deal going down, I won't see you in the car. I won't see
you ain't gonna see me in my car, none of that shit. You feel me?
Okay.
I ain't lying, man. I got you. I'm just worried about my daughter, man.
So she didn't call back yet.
I get a chance to call her again. If you don't mind.
I gotta walk all the way back to get the phone. Give me a second. When they make the phone call, you said they give you your phone back.
Yeah.
And then they start calling you. Then my man started calling you, and you like, here go doggy.
I get on the phone, I go, dog.
What does he say? Once he talk to doggy,
he answered phone. One dog called. Dog was turning the corner.
Okay, so you ain't had time to say nothing to you.
You feel me? So once I get on the phone, dog was in the corner. They went down there.
Okay. And then, how far away from where you sitting at are they?
I'm probably like. Cause I'm on the porch.
They're both. Okay, let me ask you this: does Jordan and his cousin they walk down the sidewalk or the middle of the street?
They walk the sidewalk.
Okay. Is Doggy Bone parked on which side of the street?
He facing me. He parked on I'm on this side. I'm on the left side. We on the left side, so he on the left side.
Sorry, bro. I got like 19 things going on right now.
I got you.
The left side.
The left side.
It depends on which way you come. Like,
is he right where the curb or left where the curb?
Huh?
Right where the curb or left where the curb?
Is his right? Is the tires on the right? On the passenger side of the car, are they up to the curb or the tires on the driver's side of the car?
Oh, I'm like, what? The driver side was.
So he's parked to get traffic on the wrong side of the street.
Is he parked?
Yup. When he pulled, cause when he came more colorful, he pulled up and they went down and they just pulled up right there. And they
On the wrong side of the street.
Yeah.
On the wrong side of parking.
Mm-hmm.
Okay. So, and you said that Jordan and his cousin, they're on the passenger side. I mean, they're on the sidewalk, so they're facing the driver's side of the car. So if I'm on the sidewalk and the car's parked, but the driver's side gets the curb, I'm talking to the driver. Does anybody go around the corner to talk to the passenger? Does the passenger get out?
Them trees right there, I ain't gonna lie to you, I really can't tell you if a nigga did, but no, hell no, I can't. You had the little nigga on this side and Jordan on the other side.
So Jordan was on the passenger side?
Yeah.
And his cousin was on
the driver's side.
Okay.
Or a cousin, friend, whatever.
Okay.
Now that we're fully in the truth game here, that other guy, you sure you don't know him?
I know of him. I don't know that nigga name or nothing. I don't know.
You don't know him from a can of paint. I mean, you've seen him before.
Yeah, I've seen him before. You know what I'm saying?
But you don't know his name, his address.
None of that.
If you saw him in public, you'd be like, oh, that's all
I seen him. I know him. You know what I'm saying? But I don't know him like.
But you got no way for me to know him.
No.
You don't know where his grandmama lived. You don't know where that motherfucker went to high school. You don't know none of that.
None of that shit. None of that shit. Okay. The only person who can get you that is Jordan.
And then you said that Jordan says that's his cousin? Is that true?
That's what
That's true. No, I'm saying, what you took,
they look alike?
No, them niggas ain't looking
alike. That's why you don't bring that real cousin?
Yeah.
All right, that makes sense. You know what I'm saying? Like, do they
I call niggas my cousin, they ain't my fucking cousin.
But there's certain cousins that you can't deny.
Yeah, there's certain cousins you can't.
That's like, oh no, y'all family. This ain't no play cousin, motherfucker.
Yeah, they don't look alike though.
Okay.
They don't look alike.
All right. And his cousin you ain't never seen, like you know his brother, so you were seeing most of his cousins.
No, I've seen them around, but I don't know if they real cousins.
But you know what I'm saying? When I say you see them around, like if I know his brother. You get what I'm saying?
Yeah.
I done been to family dinners.
I'm just gonna stop that video.
I just need one thing, for you to go back to 5 and 28 minutes. Mr. Berry interrupted me when I was trying to listen to what's going on.
Apologize, Judge, I'm just trying to make my record.
Understood.
And just for the record, I'm stopping at 5:42 seconds.
You said 5:28, Judge?
Yes, sir. I think it was around that time. That's good. Keep it there.
The biggest thing, and then they're not a pain in the ass, man. I'm just trying to.
No, you ain't getting no pain in my ass. No, I understand. You doing what you're supposed to do. I feel you. I told you I've been through this shit, man.
So tell me about the discussion.
So
tell me about the discussion. That's what I want to know. And then we can move on from this, bro.
That was a discussion.
What was it? Say it.
All right, look. Bullshit with y'all. I ain't even about to play with y'all. I'm done, because I already see I'm about to get locked up anyway for some shit. But I'm about to get locked up in murder.
So you don't want to discuss the fact that he's saying something that completely makes you look way worse? You don't want to discuss that?
No, I'm not saying that. No,
that's what I'm. You ain't hearing what I'm saying. All I want you to all I want to know is he's saying that you planned it.
This is what happened. I'm done.
Okay.
This was going on.
Okay. Cool. We're gonna have to go with what he's talking about.
No,
he said He's done with the, oh, you done? No, I took it as you said you was done talking to me. Miscommunication, that was my bad, that's my fault. Come on. Man, my God, but this is going on. Listen, bro, before I say anything, y'all gotta give me y'all word. That y'all gonna, I know that y'all gonna be able to do it, but y'all gonna have to figure it out. Daughter?
Sergeant Reed,
Yes.
I'm sorry, can I continue?
Yes.
Sergeant Reed, did you also have an opportunity to interview Mr. Orlando Roll Giles?
Yes.
The person you know as Orlando Giles, do you see him present in Portland today?
Yes.
Can you point to him, identify what he's wearing?
Yeah, he's sitting in a green outfit, sitting behind, turning to my left.
Your Honor, may the record reflect the witnesses identifying the defendant, Orlando Lowell Giles.
So noted.
Thank you. Sergeant Reed, when did you interview Mr. Giles?
It'll be on August 24th.
Okay. Where did you interview him?
Detroit Police Headquarters.
Prior to interviewing Mr. Giles, did you review, did you advise him of his Miranda rights?
Yes.
When you advised him of his Miranda rights, was that audio and video recorded?
Yes.
After you advised him of his rights, did he agree to speak to you?
Yes.
Or if I just have a moment, I know what Mr. Cripps is going to be objecting to, I'd like to just play that Miranda warning portion of that.
Can I see the advice of rights form?
Mr. Bell, do you have the advice of rights form?
It was provided in discovery, I believe. I don't have it with me. It's all going to be audio and video recorded.
It's not whether I have it, he has to produce it as part of his hearing.
My God, I don't have to produce the form.
You don't need form, you don't need just the form of evidence, especially if it's going to produce a video. Can I grab a water? Sure.
Sorry, Judge, it just takes a minute to load the agenda. Yes, I have what is proposed. Sorry, I have on the screen what is equals proposed exhibit number 5. So for random warnings, and starting this video at 4, 12, and 14 seconds. As long as 14.
Mr. Cripps, you have no objection to the Miranda portion of the video? Do you?
No, I don't, Judge, I'd like to do that.
All right, and then
All right, what's up, man? You all right? All right, so my name is Sergeant Reed, man. Brought you down here, wanted to talk to you or something. All right, but what's your first name?
Orlando.
Spell it.
ALANDO.
What's your last name?
Giles. JILES.
What's your date of birth?
09/23/2003.
09/23.
Yeah, 2003.
What's your address?
Address.
That you live at?
I'm moving. We finding the house now.
Well, what's the address on your ID?
ID 203.
Huh?
20317. Chapel.
Okay.
CHAP.
What's your phone number for you?
313 736 10.
Okay. So, okay, every time we come in this room, we gotta read this to people when we can have a conversation, okay? When I say I, I'm talking about you. Not talking about me, I'm talking about you. You understand? Yes? You understand when I say I, I'm talking about you? Okay. I have right to remain silent that I do not have to answer any questions put to me make any statements. Do you understand that?
Yes.
Okay. Any statement I make can be used against me in a court of law. Do you understand that?
Yes.
Okay. I have a right to the attorney, present before and during I make any questions or make any statements. Do you understand that?
Yes.
Okay. If I cannot afford an attorney, one will be appointed for me by the court. Do you understand that?
Yes.
Okay. I can exercise my right and I answer any questions, make any statements. Do you understand that?
Yes.
Okay. What I need you to do is I need you to initial by each number that I read. This is all I'm saying that I read this to you. To say that I read it to you. Just you read over. That's all I just read to you.
I figure out what I'm here for. What the fuck I need
Yeah,
to do?
so how we started is I have to read this to you, then I'm gonna explain to you why you're here.
I mean, like, what do this mean? Like, say it one more time.
Okay, so.
I don't know.
All right. Okay. That's why I asked you. So when I asked you, do you understand? Do you understand? That's what I was going to explain. Okay. So it's like I have right to remain silent. So we have to ask these questions.
Yes.
We have to read this to you before we can start talking. Okay. Whenever we come in this room, because the police brought you here, right? Whenever the police bring you in custody, they bring you down here. I have to read these to you in order to even talk to you about anything.
All right.
Okay. Doesn't mean that you're in trouble. Doesn't mean either way. It just means that in order once you're in custody, I have to read these to you.
Right.
These are your 5 rights.
Right.
Okay. They're pretty short and simple. You have a right to remain silent. You do not have to answer any questions put to you, make any statements. That's pretty simple. Just you have a right.
Right.
Okay. Any statement you make can be used against you in the court of law. I just advise you that whatever you say can be used. Doesn't mean it is. Doesn't mean anything.
Right.
All right. I have a right to an attorney present before and during the time I make any statement or make any any time during the time I answer any question or make any statements. Okay. If I cannot afford an attorney, one will be appointed to me by the court prior to any questions. Okay? You can decide at any time to exercise your right and not answer any questions or make any statements.
I don't got nothing to say.
So you don't want to make any, you don't want to answer and figure out why you're here.
Yeah, I'm trying to, that's
okay, so we have to get through this part, then we're going to start saying.
So which one I'm saying?
So I need you to initial these that I read these
Which
to.
one? Because I'm saying.
Which mean which one? I don't understand what you're asking.
Because you're saying, is this you saying Mark, what you just said, one of these questions, right?
No, I said initial that I read all of your rights to you. Right? And then we're going to start having our conversation.
Right. So I don't got nothing to say. So which one I put it in?
You don't want to say nothing.
No, I don't got nothing to say. That's
okay. That's cool. You can refuse. That's refusing is good enough for me too.
All right.
Okay. All right.
And so what refuse mean? Like nothing, I don't got nothing to say.
That means you're not trying to find out why you're here. You have.
That's what I'm saying.
No. So listen. I can't. Listen. So the thing is this, right? When you say that you want to exercise your rights, I can't sit in here and try.
So what I'm saying. So what I put.
So listen, I can't tell you. I can't.
No, I'm saying I hear what you're saying.
What I say?
I'm saying. Listen, I hear what you're saying. You're saying if. Well, I don't know.
No. So I'm just explaining what I'm saying.
I'm trying to figure out my head.
So what I can't do, because when it comes to your rights, I can't tell you. You should say something to me. Listen, I can't make you say something to me, and I can't tell you not to.
Yeah, of course, I know that. I know that.
So I have to read your rights. Now you make the decision, like, hey, do I want to find out or I don't?
Yes.
Okay, but you say you refuse.
No, I mean, because I'm trying to figure out, like, I'm thinking you were saying, like, you're saying refuse, or you saying find out what I got, find out what I'm here for. That's what I'm trying to tell you the whole time, because you saying it. Because I'm not getting it.
So
That's what I'm trying to.
I got you. I want to ask you questions. Okay, about a incident that happened.
Right. So put it on there, and I refuse. I'm trying to figure out why.
Okay, so if you want to figure out, if you want to go through the question and answer and figure out why we're here.
Yes.
Okay, that's not refusing. That's understanding your rights.
Yeah, that's okay.
Okay, so that's initially that I read. All this says is that I read those to you.
Okay, so what you want me to put it at? Which one?
No, all of them. You have to. I read each one of them to you. Okay.
Okay,
So initial your name by each one of those to say that I physically read those to you. So all it says is that I read your rights to you.
So I gotta do all of them.
All of them. Just initial right by them.
My first time.
Okay, I got you. And then I need you to sign right there next to.
You know how we're at the bottom.
Right, no, top right here. And you put a date right there.
Today's date is
the 24th, 8/24, 2023 at 4:18 p.m. All right. What grade did you finish in high school?
High school, I left 9th grade.
Okay. So did you complete 9th grade, or you completed, or you started 10, or you?
I was completed 8th grade, going 9th grade.
Okay. So you never went to high school?
No, I did with the online.
What online?
Ace Academy.
Okay. Did you graduate from Ace Academy?
No.
Get a GED?
No, I didn't get it yet.
How many years you do?
I think I did 2 years.
Okay, so it's like 10th grade.
Yeah.
Okay. Okay. All right, they're gonna ask me this. Do you read and speak the English language? I know. Listen, I know, but they make me ask these dumb questions. Do you read and speak English? Is that your primary? Yeah, okay.
I read and speak English. Yeah.
Okay. I know we talking like it, but some people don't. Yeah. Do you take any medication for any mental illness? Okay. Are you currently under the influence of any narcotics or alcohol? I got you. So, reason you, okay, so let me ask you this. Is there any idea by what reason?
All right, I'm gonna pause it. At 4:20, 30 seconds. And before everyone, I understand Mr. Chris is gonna have objections to Miranda.
Chris? Yes, Judge, it's pretty clear here that once he's going through the Miranda rights with my client, he ran up and said he wanted to remain silent. And then even right after he said he wanted to remain silent, he says to the sergeant here, pointing at the Miranda form, my client says, quote, "Put down there, I am refusing," referring to the Miranda form. I don't know how more clear a young person can be than saying he wanted to exercise his right to remain silent. He said that. And the officer says, "Oh, you want to remain silent?" He puts the pen down. And so it can't be argued. The sergeant didn't hear him say he wanted to remain silent. He simply didn't respect the assertion of my client's constitutional right to remain silent and kept right on talking to me. Now, in addition, I have additional argument is he totally misstated what Miranda means. Because part of what he said in relation to anything my client said, the sergeant came out and discussing that, he said, quote, it doesn't mean you say anything you say can be used against you in a court of law. That's exactly what Miranda means. Miranda means anything my client does say can be used against him in a court of law. He said the opposite. It doesn't mean anything you say can be used against you in a court of law. So he misstated Miranda to my client. He didn't respect his assertion of his right to remain silent, and he misstated the essence of Miranda, which is anything my client does say can be used against him in a court of law. So I believe this is a clear Miranda violation.
Mr. Bell?
Your Honor, working backwards, I don't believe Mr. Cripps's quote is correct. That is certainly not what I heard when Sergeant Reed was advising about his Miranda rights. At no time did I hear Sergeant Reed tell him the word don't, that it won't be, that doesn't mean it don't or won't be used against him. It's quite the opposite. Sergeant Reed went through, read the form, advised him of his rights. Again, I don't hear that quote that Mr. Cripps is stating. I've listened to this multiple times and I did not hear that quote. Relative to the defendant's assertion that he refused, at one point he did say, put down I refused. Sergeant Reed immediately stopped everything, and he was writing refused on the form. And then there was clarification questions from the defendant who reinitiated the conversation and asked about finding out what was going on. Sergeant Reed then re-advised him of his rights and what that meant. And then the conversation continued based on the defendant. I certainly don't see any violation of Miranda at this point.
Okay, so my take on the reviewing the video is that the defendant didn't appear to have the full understanding of the Miranda form or what was going on. Clearly wanted to know why he was there and wanted to discuss the reason that he was there. Mr. Cripps is almost correct in that what Sergeant Reed said to him about Miranda. I did hear him say something to the effect of it doesn't mean everything that you say will be used. It may be used or it may not be used. He said something to that effect. As it relates to whether this was an involuntary statement or that the defendant made a clear assertion that he did not want to talk, that wasn't the take that I got from what he was saying either. And I think we're playing with semantics a little bit in that initially he was saying that I don't have anything to say along the lines of I don't know what's going on. There's nothing you can ask me. Not that I don't want to speak or I don't want to talk to you. That was the play that I got from the very beginning. That he was saying, I don't have anything to talk about because I don't know, because I'm not involved in anything. Not that I'm exercising my right, my Fifth Amendment right not to speak or to remain silent. My take on it, however, is that the statement that the defendant gave after being advised of his rights twice, and Sergeant Reed saying, "Oh, you're refusing? You want to refuse," and start to write refuse on the form, that I did see the defendant reinitiate the conversation, reinitiate the contact. So for that reason, your objection is noted for the record. I'm sure if it does get across the street, it will be brought up again.
And the other problem I have with the judge, and again, I think it's a complete violation when to try to save this situation from try to stop my client from remaining silent, that the sergeant then misstates Miranda, where he says, I'm not saying everything you say can be used against you. And that's a complete mistake. So he's giving the impression to this young man who knows nothing about Miranda, that in fact, don't worry about it, not everything can be used against you for the law. That's a total misstatement of Miranda. And then at no time does he ever ask him at the very end, do you wish to give up your rights that I read to you and proceed with the statement? Never asked him to voluntarily relinquish his rights, which is particularly huge problem here. When he misstates Miranda to my client, and my client initially said he wanted to remain silent. So I think this is a complete abrogation of the essence of Miranda, and actually not about the statement.
Just to respond, Sergeant Reed does clarify what the defendant he specifically says. So if you do want to continue this conversation to find out what's going on, where I ask you questions and you answer questions, you need to sign here. You can't inform them. That's Sergeant Reed explaining to him, if you want to talk, here's what you got to do. And the defendant complies, he signs off, and they start talking.
In addition to that, he went through each right individually.
Yeah.
And asked him about each and every right. So I think it's a closer call, closer than I would like. But I think for the purposes of this hearing, the court is going to find that the statement is voluntarily given.
My judge, I know you've ruled on this, but I would ask for a stay here so I can raise this on appeal.
If it gets across the street, you'll have an opportunity to bring your motion in. You may proceed.
Thank you. Sergeant Reed, you were on the interview with defendant Giles. Did you have another detective participate in the interview?
Yes,
And was that Lieutenant, I'm sorry, who was it?
Lieutenant Paul Brown.
And throughout the entire interview with Mr. Giles, when you were going in or out of the room, were you watching the interview?
Yes.
So you were present for the entire interview in some capacity or another?
Yes.
Back up real quick, because I forgot to ask you this earlier. As the officer in charge of the case, were there ever any firearms found in Chevy Malibu with Mr. Wills and Mr. Garth?
Objection, Your Honor, there's no foundation. You'd be asking to this sergeant what other police officers did.
You can only testify as to firsthand knowledge.
I can understand, but I can ask, to your knowledge, as the officer in charge of the case, Mr. Sergeant Reed, are you aware of any firearms being found in the vehicle in which Mr. Wills and Mr. Garth were?
Same objection, Your Honor.
Yeah, so we're not here all day, sir. You're the officer in charge of this case, is that right?
Yes, sir. And
any evidence that's recovered, is that turned over to you?
Yes, sir. That's my evidence not.
And you're in control of, were there any guns that were turned over to you that were reported from that vehicle?
No, sir.
Sergeant Reed, were there any holsters or magazines or parts of any guns in that vehicle?
No, sir, Your Honor, same form of that question.
Any turned over to you?
No, sir.
Any other weapons in that vehicle that were turned over that you're aware of?
No, sir.
Thank you. Sergeant Reed, in People's Proposed Exhibit number 5, we just went through the Miranda. Is the remaining of this recording contain a complete interview of Defendant Giles?
Yes.
Going to remove it for the admission of Exhibit 5.
I will admit over Mr. Cripp's objection, which has been noted for the record.
Thank you, Your Honor.
Thank you, Your Honor. Sergeant Reed, did you and Lieutenant Brown continue to ask Mr. Giles questions about the homicide of Mr. Wills and Mr. Garth Kabler?
Lieutenant Brown, completed the interview.
Your Honor, I'm gonna skip 2 hours forward and start the portion of the video at 6:57, 19 seconds on August 24th.
Okay.
Better than, I don't know what the fuck was going on. I just heard shots. We grabbing weed, motherfuckers reaching in cars, we jumping in the car, we gone. That ain't working, bro. Because guess what that means? That means that this was premeditated. See, and when it's premeditated, that means ain't no getting out.
Ain't no getting out, I already know. I already know.
So it ain't about covering up nothing or try to save nobody. It's all about you gotta let me know.
No.
Shit. See what I'm saying? Because the evidence and shit don't support that this was just, hey man, you know what I'm saying? And we about to get blood.
I just told you what it is. I ain't gonna say a lot to you. You just tell me what it is. I already said.
How many guns was in the car?
I only saw one gun.
Okay. And bro, the only one that had the gun.
Yeah.
Did what's his name? That was driving? Huh?
Skirt.
Did Squirt have a heater?
I didn't see.
Okay. Where was the gun that bro had? Was it in his hand when he got back in the car?
Yeah.
Okay. Where was it at when he got out the car?
I ain't see it.
Okay. All right. Did you see him with a gun earlier that day?
How time we was shooting dice. We been shooting dice for like three hours and a half. So you probably did that once when you said come on, let's get in the car. I didn't see him just grab no gun, just put it in his pocket. None of that. We just got in the car and left.
All right. Y'all let him go to the spot, right?
Right. And he was out the car.
How did y'all know to go there though?
Nah, I don't even know. That was dope, bro. I ain't gonna lie, bro. It's dumb.
Okay.
I'm in the back seat. They get out before me. Boom. I get out. Boom. I hear boom, 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 boom. I run up.
When they get out the car, when they pull up and they get out the car, you said they got out a little bit before you, okay?
But then I'm just saying they got out. I'm still grabbing my stuff. Like, you feel me? When I get up, I don't see him. So I gotta.
Okay.
So I don't see anything. Like, turn my head up, recording the song. Like, I'm still like, back here, something there, around there, something. You feel me?
Okay.
So I can't see nothing like I would have been seeing.
So your vision is disturbed a little bit, correct?
Yeah.
They're kind of around the corner.
Yeah.
But when you get up to the corner, now what you see? That's when you see bro on the sidewalk, my man at the car. And who car was he at?
Who?
Then you said, what's his name?
George.
Squirt?
Yeah.
He was at the car, right?
Yeah.
He was reaching in. Was he the one reaching in?
No, he ain't reaching.
Okay.
Jordan did.
Okay. And where was Squirt at now?
When I look back, everybody just went to running.
Okay. And who car did Jordan reach into?
Take her.
Okay. And where were they at?
Who?
The car, the people that.
Oh, he's right there.
Okay. And when you get up to around the corner where you can see this, the person that they ultimately shot, where was he at that time?
In the car.
He in the car, right? Is he moving?
Yeah, it was moving.
Okay. What they saying?
I'm so scared right now. I just grab what I can grab and just leave.
Okay.
Just like that. I ain't gonna sugarcoat nothing with you.
Is Jordan still got the gun in his hand?
No.
Okay. Where's Squirt at now?
Everybody running.
All right. So boom, you see him. You hear the shots. Boom, 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 boom. You get up to the car. Jordan at the car. He reach into the car. My man in the car. Squirt is where again? All right, so he already taken off.
He about to take off.
So now you understand what I'm saying.
Sound better now?
You should start putting the puzzle together.
I am. I'm telling you. I just told you. I'm telling you now.
But it was other people.
Oh, was it?
See what I'm saying? What I'm saying is, when people hear things, you may not see them.
Right.
It's just like pow pow pow.
Oh yeah.
What's going on?
Right.
You see what I'm saying?
There's people.
That's just what people. They might not been out there.
But there's people do.
Man, that's fucked up, man. You know how many motherfuckers called down here? I'm looking at the file. You think they just bungee jumped on y'all ass out of the blue? They gotta support it with something. The reason you here now is because they gotta build up. You see what I'm saying?
They ain't came up.
And then when they get a name, face, name, okay, boom, all right.
Not evidence.
Who can say he was here? Who said this? Who said that? Who? And then y'all didn't rehearse the story. Y'all probably talked about it. Y'all talked about it, didn't y'all? But everybody's story ain't right. So when y'all got back to the house, what did y'all have a discussion about this? So y'all ain't never talked about this since then. You know what? I'm gonna tell you this though. I've been doing this shit 7 years. That's bullshit. You know, I'm telling you why it's bullshit.
We had to talk, but it wasn't like no long talk, so.
Alright.
I'm damn near through walls. I'm damn near through walls.
Now, I'm about to say,
I'm telling you what it is. Like,
what's your name?
Orlando.
Lando, you see how I just called bullshit on that, right?
I'm just telling you now.
What I'm saying is we've been 100 since we've been in here. You see how quick I was able to call bullshit on that. You know why? Because that's just the human anatomy. You're not going to see something so traumatic and you don't share that experience with somebody. You see what I'm saying? That's something you're going to remember forever.
Right.
And since y'all was together and y'all know y'all fucked up, y'all had to talk about it. You understand what I'm saying? So y'all got back to the house, y'all talked about it. It don't gotta be a long conversation, but what was the conversation?
It wasn't no good conversation for real. He said what he said. He said, I'm about to leave. Go ahead, y'all boys be careful and go.
Who said they was gonna leave?
Squirt.
Okay, Squirt said y'all gonna leave. What was he upset?
To be honest, I probably say I don't know. I don't know. I can't lie. I don't know.
Y'all chopped up the weed?
Yeah.
Okay. Kind of broke it down evenly? Okay. And Squirt said, hey man, I'm gone. I'm ghost. What you and bro talking about?
We chilled, sat there. My sister had made some food that night. We chilled. We didn't even really get to say nothing to each other for real.
Y'all paranoid?
Paranoid.
Y'all didn't tell sis, did y'all?
No.
Alright. Did sis ask why y'all was paranoid?
No, sis ain't been. She was at the hospital for real. So she came back. She got the baby. So she ain't talking to his other because she with the baby and all.
Alright. What happened to the pistol?
Well, that's one I don't know.
Right. It came back to the crib with y'all.
Yeah, it came back to the crib. I don't know what they did with the pistol.
Alright. Did bro say why he shot?
Huh?
Did he say why he shot?
I didn't get to ask him none of that.
Did my man have a pistol?
Who?
The dude they robbed.
I don't even know.
Okay. And you said you didn't see Squirt with one. So Squirt came back to the crib, dropped y'all off. He grabbed his portion of it, and he was gone.
Gone. Did
y'all ever meet up or talk after that?
No.
Did you ever see Squirt after that?
No.
Okay. Y'all didn't discuss it with sis?
No.
Alright. We don't know what happened with Squirt now. So when did you and your brother find out this guy was dead? I never found out he was dead. When did you find out?
We didn't find out, we know.
All
We
right.
didn't know.
You obviously know now, right?
Yeah, now we know now.
Did we tell y'all?
No,
So how did y'all find out he was dead?
I'm just saying. The officer said we getting picked up. Well, actually, what he said, this what it was. Okay, 3 days ago. My phone. Whoa. Hey, picked up skirt. Oh, damn, that's fucked up. Now they came and got him. He just got dropped up to my friend in the house. I've been there ever since. Never left the house. You feel me? Just chilling, having girls come over. You know, that's what boys do. You feel me? Chill. Boom, we come up. Boom, damn. Now I get a call saying the police about to be at Charles. Here you go. But just drop her off. Woo. Man, they instantly go straight to him. Pin me in handcuffs. Ask my name. Boo, boo, boo. I'm telling them, I'm chopping it up. Boom. They let me go.
So
they let me go, right? Boom. It's about to follow y'all to the house. He found them guns in my friend's house and whatever. And I go over there. I'm giving the little girls I was with. I take them home. I'm like, come on. I'm like, get y'all right. Get y'all home. Hey, get away from that car. Whoa, I gotta tell me get away from the car. I was just right here, you feel me? I ain't know nobody just walking up to nobody, you feel me? He, alright, you better just get back to the car. I give her a phone. Talking, calling my mom, because I'm telling my mama what just happened with my friend. And he come out of nowhere talking about you got something in the car, you left. What you mean? Now I'm paranoid now. I ran on, come here, you running for cuz? I don't know, you just come out of nowhere. I was just in front of all the police officers the second time. I just came back over to get the phone. They all right there in front of me. Could come here, let me talk to you. I would have did it. You feel me? If I didn't, I would have did it. And when did all that extra stuff for what I just did, I would just did right there to say something to me. They don't know. You feel me? I could have been down there just in case. You feel me? So, damn. Came got me around. I just got scared for some reason.
Which is that can be explained. You got scared because it don't take rocket science to figure out what happened a couple days ago.
Yeah, that too.
That's why you running.
No, I'm just saying.
I mean, but that's still
that do.
And you know they just picked up Squirt.
Mm-hmm.
And you know that Squirt was with y'all.
Mm-hmm.
It don't take rocket science to figure out what's going on.
I know.
So I'm saying? So now you gotta explain. So that's what I'm saying. It just all looked bad. And then you got people putting you involved in it.
Mm-hmm.
People ain't saying you was just in the back seat rolling up no weed.
They said I was out there.
People saying you up there at that motherfucking car too.
Yeah, I know. That's what you just told me.
So the thing is, what's done is done.
Mm-hmm.
Were you strapped to? Okay. So that thing that I was just in the back rolling weed, you was up at that car with your brother when he went in that motherfucking car.
Mm-hmm.
You were closer than what you saying you close, and I'm gonna tell you why we know you was closer. Because soon as they heard a shot, a motherfucker looked out and he saw 2 motherfuckers at the car. That's why I'm telling you, don't let another man tell your story.
I know. I already know.
So I get that you probably rolled over there rolling up the weed. But when it was showtime, you was out that car with them. Because we got people that saw y'all. That's the part, Orlando, that you gotta in your mind, you gotta say, you know what? They got us. And the only thing I can do is make this shit worse from here. People think y'all plotted this shit. Already got your ass running from the motherfucking police, showing the guilty what mindset.
Mine said that was dumb.
You see what I'm saying?
Only reason I did that because I was told, like,
But you agree that shows a guilty mindset.
Yeah.
Cause if I was just back there smoking some weed and some shit jumped off that I ain't had nothing to do, and I had nothing to be involved in it, and I had to get in the car because I came with them and I had to leave with them. Hey, officer, look, man, I was in the back rolling up weed. Shit went down that day supposed to went down. Yeah, I rolled out with him. Yeah, I went back with him. That was my brother. You know what I'm saying? But I ain't had nothing to do with that.
Right.
That's my story all day. But we know that ain't the story. See what I'm saying? We know that ain't the story. So you can't give me a baked potato and don't give me the butter or sour cream to go with it. See what I'm saying? You can't play, I was just chilling this minute. But remember, y'all came home and y'all divvied up the weed. And then, when they heard the bang, 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 they looked out and they saw two motherfuckers right at the car. Now, we know how Squirt looked. Two motherfuckers, they described it like you and your brother. And y'all was only three motherfuckers there. See, this is that part where I tell you, you got to tell it all. Because if this lady gonna be like, hold on, he trying to sell that bullshit to you? When we know he was at that goddamn car? You mean tell me, after all that time you was in there, after all the time they talked to you, then they gonna probably call my ass, but like, cause they know I don't know shit about the fucking case. It ain't my motherfucking squad. I work on the motherfucking east side. Y'all ass on the west side. Feel what I'm saying? Sergeant Brown, so you been telling me you went in there, you had a good rapport, good relationship with this young man, he still fucking lied to you? He don't know we throwing a book at this son of a bitch. That's what they gonna say. You gotta take ownership for something.
No, I'm not hearing you, man. I hear you, man.
Hearing and listening is two different things.
Yes, sir.
One thing I can say about Squirt, hey man, this what I did. This what I observed. He ain't gotta throw nobody else in it.
Yeah.
See what I'm saying? So we already know it was a robbery. We already know it was a robbery plot. Okay, we don't know what happened to the fucking gun. Okay, fuck it. We don't have to know what happened to the gun. This motherfucker was shot. He dead. You understand what I'm saying? And this, I was in the back rolling up some weed shit. We know that ain't the facts. Your ass was at that goddamn car. So what made you go to the car? That's what you gotta explain right now. What made you, Orlando, go to the car?
I was somewhere at the wrong time, man.
I get that. You was at the wrong place, wrong time. But why did you go to the car? When you went to the car, what did you do?
I grabbed the weed.
All right. You reached in and grabbed the weed? All right. Where was the weed at?
On the passenger side.
It was on the passenger side. All right. Where on the passenger side?
On the floor.
It was on the floorboard. All right. Where was my man at?
Who?
He in the car, right? Where was Bro at?
He was still right there.
Okay. So
When I grabbed the, when I grabbed the weed.
I'm you, okay? This is the car. Front door? Front door, because it's driver's side and passenger side, right? Where was the dude that was shot at? He was in the passenger seat, right? All right. Now, bro right here still, right? He at the window. You come up, you gotta reach in the car and grab past bro, past him to grab the weed. Right. You understand what I'm saying to you? Yeah. You gotta tell the whole thing. You knew it was a robbery. Because what else would take you to the car to reach past the gun and grab the weed, past the fucking goddamn victim and grab the weed? And you know he shot. Because you going past him. So, that's what I'm saying, bro. It's like that line I was talking about earlier. Okay? It's like that line. This is done now. What you don't need to be life without the possibility of motherfucking parole. You gotta figure out what I'm gonna fucking do. I'm gonna be rolling out this motherfucker in 10 or 15, or pray to God, you 20 now, about to be 20. Pray to God you don't live to be 100. You gonna do 80 in that bitch. If you don't fucking understand what the fuck going on right now. Told you. Y'all was gambling. Y'all get in the ride. Alright? Mind you, this ain't the first robbery ever occurred. You know why people usually smoke weed and get drunk before they go hit a lick? Gotta relax. It's physics. Don't you know every human body is the same? We are different, but the anatomy and the makeup of us is all the same. It's just like when you ever played basketball, football, you ever played on a basketball team or something? Everybody nervous in the locker room. Y'all getting hyped and shit. Cause it's the unknown. We going out here about to face this team. But when the ball goes up, the nerves go away. You gotta play now. It's time to play ball. So that's why people smoke weed and get drunk sometimes. Cause we know what's about to go down. But when the car stopped, it's game on. Game on. You understand what I'm saying? So we know it wasn't true that you was rolling up weed. You went straight to the car with bro. You went straight to the car with bro. And the reason I know you went straight to the car is we can scratch that people saw it because when the sounds went off, motherfuckers was looking and starting to call 911. But let me tell you how. Because science and mathematics says you went to the car with them. Make sense?
Makes sense, for sure.
There's two things on this earth that we have that is factual. Men lie, women lie, what don't? Numbers.
For sure, I know, yeah. For sure got that.
All right. The numbers is there. And the science is there. And your story don't add up to the numbers and the science.
Oh.
Because you went to the car.
I know I went to the car, but I'm just saying, like.
But the part where I was just rolling weed, they left before me.
I'm saying they did. I'm walking now. At the time hearing shots, I hear the shots now.
You went up there with bro.
Yeah.
Okay?
Yeah.
All right?
Yeah.
So don't make it
seem like it's something else. Okay, I got you.
Just tell the truth.
Got you. I walked up there with bro.
You walked up there with bro. When y'all get to the car, what happened now?
What? I got grabbed the weed.
You grabbed the weed before the shots?
No, the shots came already before.
Okay, so you walked up to the car with bro.
Yeah.
Obviously, bro produced. What did he say?
He didn't say shit.
He just went right in, boom, boom, boom.
Yeah, I grabbed the weed.
Okay, so it was just like this. Boom, boom.
I grabbed.
So how we know the weed was in the car?
What you mean?
How we know it was there?
With the weed?
Yeah. So y'all just pulled up at a random spot, walked up to a random car and knew it was weed in there?
No, they just told they already said they had weed.
Okay, that's all I'm saying. See what I'm saying? Boom. So y'all had prior knowledge there was weed there. Okay. We knew the weed was there. The thing was to go grab the weed.
Mm-hmm.
All right. So as soon as bro get to the car, do we get to the car shooting?
Mm-mm.
All right. What do we say?
He ain't say nothing.
So he just go like this.
That's what he exactly did. He ain't say
Then
nothing.
what led him to shoot?
Huh?
What led him to shoot then?
I don't know. He just shot and I grabbed.
How many shots you heard?
I tell you about like 6, 7 shots.
Okay. Now you reaching past bro. Do he still got the gun in pointed at him?
No.
Where's the gun at now?
Gun moved.
All right. So he pulled the gun back. You reach in. Do he say get the shit or what?
Nah, I just grabbed it.
All right. All right. My man in the car shot.
Yes.
All right. Do you remember what he was wearing?
Yes, sir.
All right. Was he breathing?
I think so. He was breathing.
Did he say anything?
I ain't hear him.
All right. So when you reach past him, what is the weed in between like his legs? So if he's sitting on the,
just like
it's like on, so it's like this, about it, like in between his feet and the door.
Yeah, man, like it's high or something.
Okay, like in that little part of the thing. Okay. So, do you see blood at this time?
I ain't see no blood. I tell you.
Okay. Is blood still? He still got your back while you going in the car? Is he still?
I didn't pay attention. I just grabbed and left.
So when you get the weed out of the doorway,
You throwing it?
y'all run together. Where's Squirt at now? When you grab the weed, where's Squirt?
He's running to the car.
All right, so everybody booking.
Yeah, everybody booking.
Where was Squirt when you and your brother went to the passenger door?
I didn't see him.
Okay, so he realistically was lagging behind Squirt.
Basically.
Okay, you and bro went up there, boom, boom, boom. You grab the weed, y'all gone. All right, y'all jump into the crib. Y'all get to the car. Y'all jump in the car, y'all get to the crib, y'all divvy up the weed, Squirt gone. Like, hey man, I'm gone. I'll holler at y'all. You and bro, what y'all briefly talk about?
I'm telling him, we ain't talking about nothing.
Okay, where did the gun go at that point?
I ain't gonna lie, to be honest, I didn't see John pull out the gun once she broke down the weed.
Okay.
I didn't see the gun.
Okay.
I'm trying to
Was it still in the car?
It had to be because he ain't come upstairs.
Okay. All right.
We break down the weed because I would have saw it right on the table or the floor.
So let's fast forward.
Fast forward.
Squirt get picked up.
Mm-hmm.
Now what you and bro talk about?
Nothing. He just told me.
He said Squirt got picked up.
Yep.
Is it a possibility running your head that they after our ass now?
Yeah.
All right. Did y'all discuss it?
No.
Did y'all say what happened if y'all get caught?
We know.
Okay. Y'all ain't talk about no story or what we gonna say or nothing like that? All right. Now that we got to the end of this, everything now is the truth, right?
Right.
You sure?
Yeah.
All right. If you had an opportunity to tell this person's family something, what would you say to them?
I would.
They lost their family member.
Oh yeah.
What would you say to them? They say, look, man, you got 30 minutes to speak to this man's family. What you gonna say?
Sorry for your loss. I wish it would never happen like that. over for some petty stuff. And I don't know. I don't know. It's a lot of stuff I would have said. I ain't gonna sit there and not say nothing.
You sorry?
Huh?
You sorry?
I'm sorry?
Yeah.
For what?
That it happened.
Yeah, I'm mad that it happened, yeah. Cause it was done, pointless, yeah. And it got me scared. Wow, like, come on now.
Are you mad at your brother?
Yeah.
Did you express your anger to him?
No.
Alright. So, you gonna have an opportunity to, and the reason I asked you that is because I always ask people that because sometimes some families just want to know what's done is done, but is you sorry? Sometimes that's all the family asks for. They can't change what happened. You can't change what happened. But they want some closure.
They do.
So if you had 30 seconds to talk to this man's mother or this man's father, what would you tell them?
Sorry for your loss.
Okay. You mean it?
Yeah.
All right.
But you're gonna stop the video at 7:28, 30 seconds. I don't have any more questions for Sergeant Reed now.
Cross exam.
During the video, we saw that you were writing something down.
During which video, sir?
I'm sorry,
During which video, sir?
during this video, there was the officer writing things down at the beginning.
After
Did you write any document in this case?
the constitutional rights, yes.
I'm sorry?
You want the constitutional rights, sir?
Yes, let's start with that.
Yes.
So you filled out the constitutional rights form?
Yes, sir.
Were there any other documents that you were first prepared?
I do not recall it, sir.
What is that?
I don't recall.
Do you have your file with you?
I do.
Could you check and see if there's any other documents you prepared?
Any other documents that's here?
Regarding this interrogation, such as the handwritten notes.
I can double check.
Thank you.
You say during the interrogation of Mr. Giles?
Yes.
So I have the constitutional rights that I filled out inside the one. I don't have any other notes that I would bring.
I see the constitutional rights. On the constitutional rights form, I see the word refused.
Yes,
Who wrote that on there?
I did.
And then you crossed it out, is that correct?
Yes, sir.
Did you take any handwritten notes after the interview regarding the interview itself?
Did I take any handwritten notes?
Yeah.
I did an investigative report.
Other than the investigator's report?
As I noticed it.
I don't have anything further, Judge.
Mr. Berry, did you have anything?
I do, Judge. The information that you received as the OIC in this case, you didn't have any evidence, no evidence suggests that my client shot or fired a firearm on that occasion. Is that true?
I don't understand what you're asking.
You don't have any evidence, no evidence has come before you that my client shot or fired a firearm on this particular day. Is that correct?
Not to rephrase it, not to rephrase it.
Okay, you don't understand what shot a firearm, which part don't you understand, sir?
I can't put a gun in this thing, no, sir.
Okay, you cannot put a gun in Corey Jenkins's hand, is that true?
No, sir.
Okay. And who was Squirt?
Corey.
Right. And prior to this, prior to you interviewing Corey Jenkins, you did not know who he was, correct?
What do you mean I did not know who we were?
Prior to you interviewing or arresting him, you had no idea who Corey Jenkins was, correct?
I didn't know who Corey was, sir.
Prior to you arresting him?
Yeah.
When did you arrest him?
The rest of them on August 25th.
And how, what time approximately?
Not sure. I'm not sure about the practice time. It's around noon, 1, something like that.
Afternoon time?
Yeah.
And when was he interviewed?
That same day, sir.
Do you think?
Just a couple of hours later.
All right. And you asked him if he had anything to drink?
We always offer people something to drink.
No, I'm asking you if you had asked him if he had anything to drink.
We actually did.
Did you ask him if he had anything to eat?
We always offer to him.
I'm asking you in this particular case, did you offer him anything to eat?
I believe so, sir.
That would be on the video, right?
It should be, or maybe it happened right before he got into the room, sir.
Did you ask him, so you had a conversation with him before he got into the room?
No, I'm saying when we're walking into the room, we ask him if we are in the room, we always ask him multiple times, they want something to hear.
Did you ask him if when the last time he had any sleep was?
I do not recall that, sir.
And as far as you know, there's no information to suggest that Corey Jenkins went to the car or approached the vehicle. Is that true? That would be the complaining witness's vehicle?
Rephrase your question, sir.
You have no evidence to suggest that Corey Jenkins walked up to the victim's vehicle?
No.
No evidence to suggest that he reached in that vehicle or retrieved any items. Is that true?
Sure.
There were no witnesses in this case that identified any of the defendants?
Yes, sir.
Yes, as in no, there wasn't?
Yes, there was.
Okay. You did a search of my client's residence?
Yes, sir.
Didn't recover any firearms from there?
No, sir.
What did you recover, if anything? Did you recover any evidence in this case from his home?
I have looked at the evidence list on the call with the cover police home.
With a refresher recollection?
Yes.
You have it?
From his home, we recovered empty handgun magazine, a box of 4.223 ammo, a tablet, black iPhone, another black iPhone, a black Samsung phone, a blue Vortex phone, black iPhone, black Vortex smartphone, and Northwest Level for a place of residence, and you shut it down.
There was no 223 ammunition used in this case, correct?
Correct.
Did you recover any videos from any neighboring homes?
No.
I have nothing further. Thank you.
Leader,
No, thank you, Your Honor.
sir, you were asked questions about the defendant's involvement in this case that you, based on evidence that you received or didn't receive. You recall those questions asked by Mr. Baird?
Yes, sir.
Based on your investigation of this crime, what was the involvement that you, as you see it, of Mr. Corey Jenkins?
He was part of the robbery. His phone was used to call the victim over there. He drove the suspects, the other two suspects, both victims, to the scene. After the shooting, he drove them away. He split the proceeds.
Questions based on my questions?
No questions.
Thank you, sir.
I would just like the constitutional right for marked as an exhibit. In relation to my client.
Okay.
Yeah,
Any objection?
No.
Admitted.
Thank you. I don't have any further questions.
I don't have any further witnesses to say.
All right. Any witnesses for the documents?
Nothing for Mr. Jenkins.
No, nothing on behalf of Mr. Judge.
Your Honor, I move for bind over as charged on all counts. Specifically, obviously, the felony firearm, felony possession are based on aiding and abetting theories that all three of these defendants acted in concert with one another. Specifically, I would like to address the felony murder versus the advice to Mr. Jenkins. He did indicate during his questioning that he knew that the other individuals had guns. He stated at least twice that he drove them there and drove them back from the robbery. There were two different conversations in which he indicated that he participated in the robbery. He did indicate that he was not the mastermind in planning it or participated in it by driving them there and back, knowing that he was going to rob the victims. He clearly indicated that there was talk about the robbery and quote hitting a lick prior to occurring. And indicated that it was his phone that was used, that he gave his phone to be used to my co-defendant, knowing that they were going to give the victims the location of where to meet for the robbery. So I certainly think that his participation in the robbery, knowing that there were guns involved, is sufficient for probable cause bind over on felony murder. As well as Mr. Giles, who indicated during his interrogation that there was a gun, he knew there was a gun when they got out of the car. They heard boom, 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 boom. And then stated he walked up to the car, later changed his story and stated he walked up there with Bro, and stated that he reached into the car. The detective demonstrated how he was reaching into the car, which he agreed with, and grabbed the weed. He indicated that they chopped up the weed. They split it evenly amongst the co-defendants. Your Honor, I think there's certainly sufficient evidence to show he aided and abetted the robbery. He only got this involved. Him and indicated that he reached in and grabbed it after the victim was shot. Before they took it, left together, and chopped up the weed, split it. So I am asking for bind over as charged.
All right, Mr. Baird.
There was certainly that was certainly a mischaracterization of the evidence, some exaggeration there. The evidence, Judge, my client in his interview says that he pulled up to the house, pulled up to the curb. Just before they pulled up, there was some talk about we should rob. Somebody said we should rob. So they pull up to the curb, they get out of the car, and they smoke some weed. My client, there's no evidence that my client goes up to his car. His understanding from what the evidence shows is that they were calling for some weed. Somebody was calling for some weed. The evidence stated that they asked to use his phone. And there's no evidence to suggest that they asked to use his phone to commit a robbery. They were gonna purchase some weed. And he says in his interview, I have weed. You don't need to get weed. I have weed. And they nonetheless, or somebody calls from his phone, and provides them an address. And at this point, this is just to purchase weed. There's nothing else going on, although there may have been some minimal talk about we should rob or something of that nature. And so, Mr. Giles
Let me interrupt
testified.
you just for a minute because I might be getting the defendants confused. But is it your client that was the one who said that he reached in and grabbed the weed after the shots were fired?
No.
Okay, so that was Mr. Cripps' client. Okay.
Yeah.
Your client is the one who drove them there and then drove them back from there after the shots were fired.
Correct. So he drives them there. There's no talk about a robbery when he picks them up. There's no talk about a robbery. The only time the talk about a robbery comes in is he says, just before we pulled up, there was some talk. And that's it. He doesn't know from what he says in his interview that a robbery is gonna go down. He doesn't know what's happening. Mr. Giles also in his interview says that Squirt, who's been identified as my client, he doesn't even know where he is when they walk up to the vehicle. And that when shots are fired, my client is running to his car. I guess they jump in his vehicle. And at that point, he realizes that one person had a gun. There's no talk about any gun being present prior to that. In fact, Giles in his interview states that I
can't use what Giles said as it relates to your client.
I understand that.
You don't want me to do that.
Well, I mean,
only when it favors your client?
Only when it favors my client would be helpful.
No.
But what I'm saying, Judge, is that the evidence that has been put forth to this court, there is no evidence that my client knew of any gun, not a scintilla of evidence that my client knew of any gun prior to all this going down. The only time the gun comes up is when they jump in the car, and I guess Dub or somebody may have had a gun.
Okay, so maybe I'm confusing clients again, but I could have sworn it was your client that said that he had seen the gun.
Correct, when they jump back in the car
This was
after.
before the shoot.
No, it was not before the shooting. And I would ask the court to play back that video if the court needs to, before it makes its ruling. So my client does not assist in the robbery in any way. And for those reasons, I would ask that the felony murder be dropped. He didn't have the intent to hurt somebody with great bodily harm. He didn't have the intent to murder. There's no evidence here to suggest that. And he didn't know that there was a great risk or a very high risk that great bodily harm would occur. He's simply hanging out, smoking some weed. As a matter of fact, he says he's chopping up some weed on the porch when somebody asks to use his phone. Doesn't know that the phone, there's no evidence that the phone is being used for the purposes of setting somebody up for a robbery. They had purchased weed earlier, and they were calling them back. The person to purchase weed was the testimony. My client wasn't even with them at the earlier that day. So there is, as to the felony murder charge, that should be dropped against my client. It should be dismissed. As for the felony firearm and felon in possession of a firearm, the OIC testifies that he cannot put a gun in my client's hand. My client, there's no evidence to suggest that my client encouraged or assisted in procuring a weapon for this event to take place. And for that reason, there's case law that my client being present and at the scene for a felony firearm is not enough. He has to have known and assisted in some way.
Mr. Felon, as to the felony firearm, how do you get felony firearm against Mr. Jenkins?
He knew that there were guns being used, Your Honor. He did indicate in his interview that they had guns. Knowing that they had guns, he drove them.
Doesn't he have to be in possession or aid and abet?
He did aid and abet. He allowed them to get in the car with the guns, drove them to the scene, and then after the shooting, he says they actually had the gun in his hand when they got back into his car, drove them away from the scene. That's aiding and abetting for felony firearms.
That, I would disagree. That's more of an accessory issue after the fact. That's not an aiding and abetting issue. There's nothing to suggest that prior to the crime taking place, that my client knew that there were any guns involved. Nobody says that prior to the fact that any guns were involved.
Defendant.
He says after the fact, when they jump in the car, and he sees a gun. So for the following, for all those reasons, Judge, I would ask the court to dismiss all three counts as against my client that he didn't assist or participate in any type of robbery in this particular case. All right, Mr. Cripps.
Thank you, Your Honor. Your Honor, the defense on behalf of Orlando Giles would ask that we dismiss the charges against him. As I reserved the argument, it was made over objection of my client's statement.
I've already ruled on that.
I know you did. But the essence of felony murder and felony firearm has not been established here in relation to my client. There's no eyewitnesses to this offense. So we're
That's witness that people have against your client is your client himself in the statement that he gave.
right. But 90% of what you heard is the officer in charge just talking and speculating, and my client's just sitting there. Sometimes just humming along as the officer talks. What he did clearly say is at no time was he part or had knowledge of any plans to rob anyone.
So what about the whole taking of the weed?
I'm getting to them.
After the shoot, nonetheless, who does that?
There's no plan. I'll get to that in a second, Judge. I know that's all there really is here. The second thing is he never said he saw a gun in possession of anyone he was in the car with. He told the officer a number of times that he didn't see a gun when they got in the car. He didn't see a gun while they were in the car.
But even worse though,
He didn't see the person get out.
he takes actions after the gun is fired.
But he didn't know anybody from that car did the shoot. He never said that. You can listen to the whole thing over and over again. He never said he saw anybody shoot. He said he heard shots. Boom, 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 his words. Who it was, we don't know. But then he said he got out of the car, went over, took advantage of the situation, reached in, grabbed the weed, and left. And when he got back in the car, he's asked by the officer if he saw a gun. He said no. So we have a scenario event. We don't know who did the shooting, at least it hasn't been introduced in my client's statement. And all my client, the only admission he made was taking this weed after somebody else did something that he didn't see. How does that make him an aider and abetter to felony murder?
Because the law says any amount of aid or assistance you give another commission of crime is just as guilty as you did it yourself.
I don't think he was working with anybody else. I think he went in there, just took advantage of the situation and grabbed the weed and left.
Tell me why that would be a question of fact for a trial.
Because he had no knowledge of robbery is gonna occur. He had no knowledge of shooting was
the
gonna
robbery
occur.
himself.
I'm sorry.
He commits the robbery himself.
But now, he didn't have a gun. Nobody ever said,
Somebody else used it.
but he never saw,
Essence of aiding and abetting.
he never saw a gun at any time, according to his statements to the police, at any time. Before, during, or after. And
That
it's
was during, when the shots were fired, and you got two guys in the car dead.
he didn't see anybody shooting, according to him. He just heard the noise itself.
How could you miss those two dead bodies in the car?
Well, he saw that, Judge, but we don't know if anybody unrelated to our, the people in the car actually did the shooting. He never said he saw that. It's not here on the record. That's the problem. When he's gonna rely on, all the prosecutor has to rely on is this statement that's introduced. It's pretty vague. And when somebody says, I had no knowledge there was gonna be a shooting, I had no knowledge there was gonna be a robbery, I never saw a firearm before, during, or after, and we have a felony murder charge against him. All he really did is took advantage of the situation, went over, grabbed some weed.
How long are each of these videos? I played approximately half an hour of each video, but relative to Mr. Cripps' claim, Mr. Giles, he specifically stated, he walked up to the car with Bro, he shot, and I took the weed. And he also indicated in the very beginning, when I started the video, that he knew that there was a gun. The detective asked him how many guns, he said there was one gun. He got out of the car with it.
I do recall that.
It's all in the video that was played today.
Well, things are said by the officer that aren't necessarily agreed to by the client.
All right.
And in addition, there's no evidence at all from felony firearm.
Your Honor, relative to the felony firearm, obviously, there is a specific criminal jury instruction 8.2, which applies specifically to aiding and abetting a felony firearm versus the crime of possessing a firearm during the commission of a felony or attempted commission of a felony was actually committed either by the defendant or someone else. Second, that before while the crime of possessing a firearm and committing or attempting to commit a felony was committed, the defendant did something to assist in carrying, using, or possessing a firearm. Both these defendants aided and abetted the use of a firearm. Mr. Giles is walking up with the individual that he knows got out of the car with the firearm, he knew a gun was involved. They're going to do a robbery. His friend starts shooting. He's assisting his friend, grabbing the weed. He even states that they later.
How is he assistant in the carrying the weapon?
Well, assistance doesn't mean like physical assistance. Encouragement also counts under the law as assistance. Him going there with him, committing the crime, participating in stealing weed is obviously encouragement for the armed robbery and felony firearm. This robbery wouldn't have occurred had it not been for the gun involved. Under the specifically criminal jury instruction 8.2, he was assisting in carrying, using, and possessing a firearm by going to the location with Mr. Giles and participating in the robbery itself. As it pertains to Mr. Jenkins, under that same theory, obviously Mr. Jenkins knew. I understand defense counsel's argument is different, but in the interview, he indicated that he knew they had guns. He indicated that there were shots fired. He indicated that they had guns prior to the robbery. He specifically talked to them prior to the robbery about getting away and doing the robbery. He, being Mr. Jenkins, was specifically the one that drove them to the location knowing there were guns. It indicated that they came back with the guns in their hands and drove them away. That's certainly aiding and abetting the possession of the firearm by driving them away with that gun, going there, knowing that they're going to commit a robbery.
As I see aiding and abetting a firearm, I think he's misstating what the law is. Was there any evidence my client provided a gun? No. Is there any evidence he helped get rid of a gun? No. Is there any evidence he provided ammunition or assisted in any way in the procurement of that gun or the use of the gun? None whatsoever. It's just simply not here in terms of aiding and abetting argument for that specific target felony firearm. Just because he may be present when somebody else does something that he didn't agree with, doesn't mean that he's an aid or abetter to felony firearm.
May I read part of the 8.2 for the court, the aiding and abetting? It says, it is not enough to find that the defendant did something to assist in the commission of the underlying felony. By words, acts, or deeds, the defendant must have procured, counseled, aided, or abetted another person to carry or use or possess the firearm. So encouragement here is more like, hey, bring a gun with you, let's go do this. It's not participating just in the underlying felony. And they specifically pointed this out in People v. Moore. And that's 470 Mich 59. That's a 2004 case where it said that you can't just look at the underlying felony, we got to look at the felony firearm in itself. Thank you, Judge.
All right. Give me a moment. I want to look at this video. One second.
Number 6 on the screen.
Yeah.
You identify your report what that is.
That's right.
It says, even if it comes from life, it's still fast. I don't understand what they're on.
Okay, so far I've heard that the client knew they had guns and they were talking about robbing a guy that they bought some weed from earlier in the day.
No, he
That's
doesn't.
exactly what he just said.
Right, but then later on, he puts it into context and he says he doesn't see the gun until they get in the car.
It's not
When
what
they're
you just
leaving.
said. It's not what you just said, Mr. Barry. All right.
Can I hear that, Judge? Because most of it is the officer testifying, and not
No,
my
I
client.
heard this from your client.
Okay.
Officer wasn't saying anything.
Okay.
Your client said, right when he started crying and talking about they just don't care about me, they don't care about my kids. And then he spilled that. He said, they got in the car, I'm looking at the guy behind me because I don't know who this guy is. I don't know who he is. They both got guns. And then he said, I scrapped with the guy earlier on in the year. He said that they both had guns and they started talking about robbing this guy that he bought some weed from earlier in the day.
I just don't, I'm sorry, Judge, I don't remember that.
Well, you have discovery, you can go back and look at it in your own time.
Right.
Okay. So as it relates to Mr. Jenkins, Corey D. Jenkins, the court is satisfied that they met their burden of probable cause as it relates to count 1 felony murder, count 2 having a little bit of an issue with felony firearms. In that my understanding with a felony firearm that you must aid or assist someone in possession of the firearm. Because someone gets in a car with you with the firearm does not necessarily mean that you're aiding and abetting them in the possession of that firearm. Not looking at the offense itself, which is the murder, but the felony firearm, because he gives him a ride, knowing that he has a gun does not mean that he is assisting him in the possession of that firearm. So the court is not satisfied that the verdict probably cause as related to count 2 felony firearms. That's not as to count 2, I'm sorry, that's as to count 3. The defendant number 2. Probably dismiss that for insufficient evidence, will bind over on the felony murder. This is arraignment on the information, date, time, it will be October 3rd, 2023 at 9:00 a.m. Defendant will be remanded to the custody of the Wayne County Sheriff.
Just to be clear, Your Honor, is the court not bound over on count 4, possession by a felon or?
So I am binding on that as well. As well as count 4.
Right.
So count 1 and 4, count 3, yes, defendant number 2. All right, now let me see, Mr. Chris. Yes. Take that. Okay, so my common sense and everyday reasonableness leads me to believe that this defendant knew full well what was going on when he reached into that vehicle and took the weed out the passenger side of that vehicle after hearing shots. When I say common sense and everyday reasonableness, you hear shots, you don't know, and you claim you don't know who's shooting, you don't know if somebody's shooting at you. So why do you have the presence of mind to reach and grab to steal some weed and then take off running and get into a car with other people that are running and you see that they had guns? Just doesn't make sense to me, Mr. Cripps. Not gonna fly. The court, after hearing testimony of the witnesses and viewing the people's videos, satisfied the people that the verdict of probable cause as relates to count one, felony murder as it relates to this defendant. I guess I have the same issue with the felony firearm as to count two with this defendant. There's been little to no evidence whatsoever that this defendant aided and abetted the procurement of that weapon or the weapons that were used. There's been no testimony that he was in possession or that he aided and abetted someone else in possession of a firearm just because they were together, or just because they may have approached the car together, or just because he participated in the initial crime, which is the murder. So as such, the court is not satisfied with the people that the verdict of probable cause as relates to count two, and will dismiss count two for insufficient evidence. The court is finding on felony murder. Sorry, no. Felony murder. This arraignment on the information over in Lane County Third Circuit Court will also be October 3rd, 2023 at 9 o'clock a.m. And it will be remanded to the custody of Lane County Sheriff. Thank you much.
Thank you, Hunter.
Thank you, Your Honor.
Mr. Mayor, Chris, I need dismissals as the council.
Go straight to the elevator, please.
Yes, Judge. What?
Good day, Your Honor.
Thank you as well. Family, my condolences to you for your loss. Senseless. That's good. I didn't even get to say bye to my YouTube people.
Oh.
That's it for today, folks. Hope to see you tomorrow. Same bad station, same bad time.